ক্যামেরা রাখিয়েছে লাইভ পিছাটো আহিব নালাগে ঠিক লাইভ notice in this case was issued on 20/07/2018 and the registry has wrongly listed this matter for motion. Pursuant to the order of the court dated 20/07/2018, registry also received the relevant records from the Foreigners Tribunal, Bongaigaon number 2 of F that was called for by order dated 20/07/2018. Thank you. Yes. Yes, Mr. Sutradhar, we have seen the record.
Lordship, it is a expertise, Lordship, and
Do you want to say it's an expert? When the proceeding did not appear in spite of granting.
Lordship, she is
We
the
have seen from the records that whenever she feels like she will appear and whenever the tribunal gave 3 notice during the entire proceeding. The proceeding started on 16th of July 2008 and the proceeding appeared before the tribunal on 17th of September 2008.
Yes.
And because of her non-appearance, the matter was dragged. And later on, by the impugn opinion, the matter was fixed for hearing at the instance of the petitioner. And ultimately, the order was passed after granting several chances on 19/5/2016. Just imagine from 17th of September 2008 to 19th of May 2016.
Lordship, she has genuine
Almost 3
documents.
years.
She casted
Whatever
her
you
vote
say.
in 1970, Lordship.
That doesn't matter, Mr. Sutradhar. She is supposed to place it before the tribunal. She
Lordship,
approved it. The thing is this, she was reluctant. How much the tribunal can approve?
teasing Lordship is a elected person and aging lady, Lordship.
Those are, we can understand.
Aging lady, Lordship.
That is aging, illiterate, that will not do. The matter relates to the nationality of the petitioner. If it is not voted, let her not be voted.
Lordship, I'm praying for that this matter may be remanded back to the.
For why? For what? What is the reason to be
For
remanded?
evidence, Lordship.
Why? It is not that the petitioner was not granted chance.
Lordship, evidence, she could not laid
The
her
matter was
evidence.
fixed for hearing at her instance. She appeared and paid for hearing. She said that we have filed the document. The matter be fixed for hearing. Accordingly, tribunal fixed the matter for hearing.
Lordship, she submitted all her documents to her engaged counsel, Lordship.
Don't blame the counsel. It is the duty of the proceeding to prove her matter. Don't blame the counsel. You are also a counsel.
One last chance may be given
We
to
can
her.
consider everything if you deposit 10,000 cost to the Secretary Legal Services Authority, Bongaigaon, on or before 24th and appear before the tribunal on 26th.
Can it be, Lordship, 5,000?
No, this kind of conduct of a proceeding, otherwise it's a case to be dismissed.
Yes. Lordship, that then this order may be passed, Lordship. She will appear.
Subject to the payment of cost. And she fails to appear on 26th and on the dates fixed, the matter will be dismissed.
Yes, Lordship.
Yes, yes.
And she will file her evidence, Lordship.
Nothing. At her instance, matter is fixed for hearing. What for everything? She has already filed the relevant documents. It will be at the stage of hearing only. What for evidence?
Because the original documents she could not produce.
Produce it at the time of hearing.
Because Lanet Tribunal, Lordship, has gone to the photocopies of the voter list and all, and
You produce it, prove it during the hearing. We have nothing to say. It will be fixed for hearing and we are not interfering in that order. You appear.
Lordship, that liberty that I may be prove the documents by editing the original
Documents during the time of hearing, that's all. 10,000 to be deposited before the Secretary District Legal Service Authority, Bongaigaon, on or before 24th. To appear before the Foreigners Tribunal. Bongaigaon number 26th. 27 June. No notice is referred to be issued to the prosecutor as the order has been passed in the presence of the council for to appear before the division along with the receipt of such deposit. Receipt in order. Is the
আপনার লস-
আজকে মেরি ফোর্টি ইউনিয়ন অফ ইন্ডিয়া two three four two 4257. H. Kuli. Running on the Peter Mark.
এক নম্বর সুযোগ
Yeah. That's the matter.
in this case not hearing of peaceful healthcare action হয় hearing of peaceful এটা একটি নাই কারণে একটা কথাগুলি খুব ক্লিয়ার হয়
Yes, Mr. Day.
What notice of motion was issued, my lord, on 3/8. It was on 18.
Notice in this case was issued on 03/08/2018. The registry also received the relevant records from Foreigners Tribunal number 2, Bongaigaon, Dr. Puri. And it was called for by order dated 03/08/2018. The petitioner is in interim protection since 03/08/2018. Issue notice, issue rule. Release the matter for hearing on a date to be fixed by the registry. As by the impugn order dated 08/06/2017. Passed by the Learned Foreigners Tribunal, Bongaigaon, number plate of Bachelor. In BNDN of FT case number 1974/07. The petitioner has been declared to be a foreigner under the Foreigners Act 1946, who got illegally entered into the territory of India from Bangladesh on or after 25/06/1971. This shall appear before the Supreme Police Order, Bongaigaon, on or before 19th of June, and shall obtain bail. The condition. List it. List upon. Student 07/2018.
Yes, please, your lordship.
Registry received the relevant records from the foreigner tribunal Kamrup number 1/141. It was called for by order dated 20/07/2018. plus called for by order dated 2007. Petitioner is also interim protection since 2007-2018. As the petitioner, yeah, go to me to she, huh? As the learned member, learned Furnace Tribunal, Kamrup Metro number 1, Guwahati, in FT within bracket DB, case number 10578 of 2011, by order dated 25/01/2018. After hearing the parties opine the petitioner to be a foreigner who had under the Foreigners Act 1946, who had illegally entered into India on or after 25/03/1971. The petitioner shall appear before the Deputy Commissioner of Police, Border, Guwahati, on or before 19 April 2023. Tara Kotin will be imprisoned to business for the Yes, appear before the Deputy Commissioner of Police, Border.
Lordship, in this case, kindly allow us to file one additional affidavit, Lordship. The
Because appear-
sibling of the petitioner was declared Indian by the same tribunal, Lordship.
When
13/4/2022, the sibling of the
did you
petitioner.
state it in your written statement before the tribunal?
No,
that-
Lordship.
why?
After that, the case of the sibling was.
Huh?
After my written statement, the case of the Gunadhar Roy was held in the tribunal, Lordship.
Do you have your copy of the order?
Yes, Lord.
This may- Yes, sir. Bye, please. It's a different person, Gunadhar Roy.
He is his sibling, Lordship, petitioner's sibling, Lordship.
Have you stated so in your written statement before the tribunal? In the case of Monmohan Rai? So. If you haven't done, then how will you place it?
Lordship, the case of
That's it. During the deliberation of the matter. What's your good name?
A. Hussain. A. Hussain.
Counsel appearing for the petitioner submitted. That in a similar case, under the Foreigners Act. Same Foreigners Tribunal. Foreigners Tribunal, Kamrup Metro number 1, Uluburi, Guwahati, in FT in bracket DB case number 925/2018 against his brother Sri Gunodhar Roy. By final order dated 13/04/2022, opined that he is not a foreigner, his own brother. Call for the records of FT Wicket TV, case number 925/2018, decided arising out of police case number 3878/1999, decided on 13/04/2022 from the Foreigners Tribunal, First Kamrup Metro, Ulubari, Guwahati. ঠিক আছে, বড়ুয়া, একটা photocopy করে এটা তোমার। But you have not stated in your written statement
Lordship,
that there is any sibling of you. Expect a copy after some time.
highly obliged.
Also, in this matter, the victim's mother approached the Orang police station. Lot will find the FL page. Page 11 is the side copy and 12 is the one is the other. The information was provided of her missing daughter on 1st of April 2024. And the case was registered. But the police never searched for the victim daughter. And also used to say that you come day after tomorrow, come tomorrow. That is the approach taken. Then after that, it's page 16. then by not getting in fruitful result from Orang case, page 16. But you will find at page 15 the typed copy, but in page 16, in top of the address is wrongly written. But Roshmi kindly come to middle para. উক্ত ঘটনাটি ওৰাং ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মহোদয়ক 1/4/2014 তাৰিখে অৱগত কৰাৰ পিছতো মানে 4 লিখিছে তো ইয়াত লিখাত কৈছো মানে 114 লিখিছে ন 114 page 16 last page পানে কৰিব the middle para উক্ত ঘটনাটি ওৰাং ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মহোদয়ক 1/4/2024 তাৰিখে অৱগত কৰাৰ পিছতো উক্ত ঘটনাটি কোনো ধৰণৰ ব্যৱস্থা হাতত লোৱা নাই। That was communicated to the superintendent police.
The incident happened on 8th of April, and how you have made it on 1st April?
That is another mistake. That is mistake of the person who committed.
No, but you see, even in this letter, if you come to your FIR,
Yes, madam.
at page 12.
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 28/4/2024 তাৰিখে সন্ধিয়া কাম কৰি ঘৰলৈ আহি দেখা পাওঁ যে মোৰ একমাত্ৰ ছোৱালী
Yes.
সীমা সিংক বয়স 15 বছৰ, something is not legible.
And also, Roshmi kindly
So,
right hand side of the
yes,
particular page 12.
page 12.
Then page 12, that is 1/4.
How can be 1/4? It should be 1/5.
1/5.
It's not 1/5.
1/5.
Incident happened on 28th of
But it is
April. It's 1/5.
It has to be 1/5.
Cannot be 1/4.
In FIR, it is recorded as 1/5/2024, page 14.
That we have seen.
The mistake is tangible, but the approach of the police cannot be appreciated. Mistake made.
If you look at the paper, Protitin or Assam Tribune or any other
And also,
newspaper,
the
in that,
public has already reacted that Uram Thana was already being out.
particularly from Udalguri district,
Yes, ma'am.
you will see lots of missing persons. Male, female, minor, major, lots of photographs.
I also used to go to Udalguri. It's a dicey place.
Udalguri, it's I don't know why. While we used to look after the juvenile justice, in fact, we found from the grassroots that because of the awareness brought to the notice of the people, or they were made aware, at least the parents are now filing the FIR. That is important.
This person
Yes,
from-
Mr. Sharma,
Lawsuits, already case is registered, investigation going
we
on.
have seen first of May, let us know, it's a minor.
Minor, my lord,
Any,
as per my information, that.
One page is
Puran
there,
police
your-
was
Page number 10.
Police station घेराव by the public. Both the, have love affairs, my.
get the information
Yes, yes, Lord.
about the accused, about particularly about the girl, whereabouts.
Yes, yes.
We want her safety first,
Yeah.
right? Is a minor.
And page 10 here also, the certificate
Okay.
of birth.
We'll have it on 14th, Friday.
Also, minor correction
Correction.
have to be made at page 3. Page 3, Secretary to the Government of Assam, Home Department. That's not written. Page 3.
There are no, not the, any department, my lord. It is
Secretary Home, you want to
Home
be-
Department.
Have to-
put it, correct it, and give your initial. Third, Mr. R.P. Hazarika, Learned Counsel appearing for the petitioner, and Mr. P. Sharma, additional senior government advocate Assam for all the respondents. Number one,
ಇದು ಪಾರೆ last talk. ಇದು ಬಾತ್
Four.
ಕೊಡು.
Mr. Hazarika is allowed to correct the name of the respondent number one
Include the party of.
by incorporating in Kolundiba home. After secretary. By hand. Which is an issue. Matter relates to taking away by of a minor girl, or taking away of the minor daughter of the petitioner by the FIR named accused on 28/04/2024. And on the basis of an FIR, written FIR lost by her on 1/5/2024.
Copy এটা দিবি extra copy এটা। Extra copy এটা দিবি। ও পারে। Party তো না করলে, হ্যাঁ। না, ওরা থাকো তো এরকম। কিন্তু কলেজে দেয়া হয় তো।
Orang Police Station. Case number 43/2024. Under section 366 IPC was registered. It is submitted by the petitioner that though the said FIR was registered on 01/05/2024, our minor daughter is yet to be traced out, is yet to be traced, and that police is not taking proper steps for her recovery. List on 14/06/2024. Enabling the respondent numbers 3 and 4 to place the up-to-date status regarding the Orang PS case number 43/2024 noted above. 3 and 4 লিখতে যে সুপারিনটেন্ডেন্ট পুলিশ Utalguri and the officer in charge of officer in charge of Orang police station. Orang for the recovery of the victim. Copy of this order to the official. Mr. Hazarika, kindly serve him 2 extra copies. You correct it by hand. Put your initial.
Five করে দেবো।
Yes,
Lordship. Perhaps in respect of item number 5, Lordship, service is not yet complete, Lordship. And regarding item number 6, Lordship, service is completed and Lordship
you
in
have
both
not
the
taken steps. That is the note.
Lordship.
You have not taken steps.
Lordship.
You have not taken steps.
Lordship.
Hmm?
Two days time may be allowed, Lordship. I will take this step. Six.
In WPC 264. You are appearing?
Item number 6, man.
Notice in this case was issued on 12/05/2017. And the records of FT case number 146/2012 the Foreigners Tribunal Harakandi was called for. It was disposed of on 11/7/2014. Office notes reflect that the record of said FT case number is yet to be received. Though reminder was issued earlier. Moreover, the petitioner is yet to take steps. The sole respondent. Petitioner shall take steps for sufficient notice on the sole respondent by registered post with AT on or before 31/05/2024, providing its correct and for
So ST border also Lordship. I can
petitioner shall also take steps sufficient notice on the sole respondent to the officer in charge of Hailakandi Police Station. To the register please. And the officer in charge. Obtaining necessary acknowledgement from him in that regard. Thereafter, the officer in charge of Hailakandi Police Station shall submit its report to the registry of this court. Registry shall issue reminder for the records of application number 146 of 2012. Decided on 11/07/2014. That arose from the police inquiry number 42 of 2011 from the Foreigners Tribunal Hailakandi. The petitioner shall also inform the Foreigners Tribunal Hailakandi as well as the Superintendent of Police Border Hailakandi with regard to the records of said application number 146 of 2012 that was called for by the court on 12/5/2007. Failure on the part of the hearing authorities of the personnel to provide the records of application number 146 of 2012 of the Foreigners Tribunal Hailakandi. Court shall consider to pass consequential order against such person. Copy of this order be furnished to Mr. G. Sharma, standing for Home Department, appearing for the petition or is necessary. But Mr. G. Sharma, learned counsel appearing for the petition, and Mr. FKR Ahmed, learned counsel for the sole response. Service is complete.
Not copy that.
Service notice is complete on this. By order dated 22/05/2017, while issuing notice, the court called for the records of FT case number 148 of 2012 from the Foreigners Tribunal Hailakandi. Earlier, thereafter on 19/4/2024, the court passed another order for the records of the said case along with the records of FT case number 146 of 2012 from the Foreigners Tribunal Hailakandi. However, the office note reflects that as on date, the relevant records from the Foreigners Tribunal Hailakandi are yet to be received. List on 27th of June. Next to liquid, list on 27th. Separate or only second case to liquid. List along WPC number 2648.
May I please your lord. Well, the petitioner is on interim bail, man. He appeared before the border SP, but biometrics order was not that time.
Notice in this case was issued on 01/09/2017. Registry already received the relevant records from the Foreigners Tribunal number 5 at Walpara. It was called for by order dated 01/09/2017. The petitioner is interim bail, protection and interim bail since 01/09. issue rule. Registry shall list this matter for hearing. And it will be fixed by the petitioner shall appear before the Superintendent of Police Border Golpara on or before 28th of June for capturing her biometrics, fingerprints, right? Condition.
Obliged.
But Mr. A. Dekal, Learned Counsel on behalf of Mr. S.
I am not on record, Lord.
Yes, yes. On S. Kakati, counsel for the petition. Notice in this case was issued 01/09/2017. Registry already received the relevant record of the Fairness Tribunal Jorhat. It was called for by order date 190. Petitioner is interim protection and interim bail since 1/9/2017. Petitioner shall appear before the Superintendent of Police Border Golaghat on of the accepted for capturing her. Condition.
Obliged, Lord.
Okay, okay.
Notice in this case was issued on 9/2017. Registry already received the relevant records to the Fairness Tribunal, Nagaon, court number 7, Longpa. Project at Longpa. Interim protection, and interim bail since 6/9/2017. Rule hearing to appear before the Superintendent of Police Border Hotai on or for protection of her, for capturing her biometric fingerprint. Condition.
Obliged.
Notice in this case was issued on 15/9/2017. Registry already received the relevant records from the Fairness Tribunal, Nagaon, court number 7, Longpa, Hotai. Interim protection, interim bail since 15/9/2017. Rule hearing to appear before the Superintendent of Police Border Hotai on or before same date for capturing her. Condition.
Hello.
Notice in this case was issued on 15/9/2017. Registry already received the relevant records from the Fairness Tribunal 6 since Achar. Interim bail 15/9/2017. Rule hearing to appear before the Superintendent of Police Border Kachar Silchar for capturing her biometric. None appeared for the petitioner on call. Two names of three councils have been reflected in the call. Petitioner is on interim protection and interim bail since 15/9. Placed on 5th. That's
After lot of bad report and adjournment also.
Notice in this case was issued on 20/09/2017. Registry received the relevant records from the Foreigners Tribunal, but it was called for by order at the 20th. Petitioner is interim protection and interim bail since 20/09/2017. Issue rule hearing relative to petitioner shall appear before the Department of Police order. Sivasagar. Honor before. Be for capturing his biometrics.
Deep privilege. May,
Notice in this case was issued on 15/11/2007. Registry received the relevant records from the Foreigners Tribunal. Ipu Rabianko. That was called for by order at 15/11. Petitioner in interim protection, interim bail since 15/11. Rule hearing appear before the police order. Rabianko. Ipu Honor before 21st for capturing his biometrics.
Let me tell her seat.
Notice in this case was issued on 15/11/2007. Registry received the relevant record for Foreigners Tribunal for account of record. Petitioner is interim protection interim bail since 15/11. Rule hearing to appear before the Supreme Police order on account. Honor before 21st.
I tell her seat.
Notice in this case was issued on 17/11/2017. Registry already received the relevant records from the Foreigners Tribunal number 4 Kamru. Interim protection, interim bail since 17/11/2017. Rule hearing to appear before the Foreigners, Supreme Police order Kamru Patamin for capturing the 20 bis June. No representation on behalf of the petitioner on call. Two names of two councils have been reflected in the contest. Petitioner is interim protection since 1/12/2017. Yeah, go to the list of 4. Notice in this case was issued on 1/12/2017. Registry already received the list of 11 records. Finance Tribunal number 4, Nalbari, ad hoc report. Interim protection, interim bail since 1/12/2017. Rule hearing to appear before Supreme Court Police Court and on a 20 for capturing these.
Lordship, I may be allowed to go through the case record, Your Lordship. I may be allowed.
You can, in presence of the counsel for the particular respond. You are appearing. Notice in this case was issued on 1/12/2007. Registry of the received the relevant record for the foreigner number 8.
15 to file a
আমাক দিব লাগিব না 19 টো নালাগে না
reporting.
Interim protection, interim bail 1/12/2007. Rule hearing to appear before Supreme Police Order Borpeta on or before 21st for capturing heart.
Actually, in item number 17, Lordship, I could not pay here.
File to 70.
Lordship, it is already. Yes.
Notice in this case was issued on 1/12/2017. Registry of the received the relevant records from the Finance Tribunal number 5, 1 at Kolkata. Interim protection, interim bail 1/12/2017. Rule hearing to appear before the Supreme Police Court Kolkata on or before 21st of June for capturing her biometric.
Deeply obliged, Lordship.
No representation on behalf of the petitioner and court. Do names of 4 councils have been reflected in the context. The petitioner is in interim protection and interim bail in 16/12/2007. List on paper.
Yeah, please, Your Lordship. The petitioner is on interim bail since 16/12/17, Lordship. Biometric has not been given.
16/12/2017. Notice.
21.
Registry already received the relevant records from Finance Tribunal number 5, Metro Guwahati. It was called for by order dated interim protection and interim bail in 16/12. Rule hearing to appear before the Deputy Commissioner of Police Board, Kamrup Metro at Guwahati on or before 19th for capturing her biometrics. Is for the Notice in this case was issued on 18/12/2017. Register the receipt the relevant record in the foreigner tribunal forfeited gain. By order the 18/12. Petitioner is interim protection and interim bail in 18/12. Rule hearing to appear before the Supreme Court police order forfeited. বরপেটা আর বজালি নাও। This is Soliavari. Because the police station Patasar Kusi subdivision Bozali. Patasar Kusi will be in the Bozali district, I believe.
Patasar Kusi मेरे बरपेटा में right now बोजाली
Patasar Kusi
बरपेटा district
বরপেটা আর বজালি।
बरपेटा
Patasar
बोजाली
side Patasar Kusi Borpeta.
SP बरपेटा
Find out a village.
बरपेटा
Bozali Borpeta.
बरपेटा
Here is to Kannada jurisdiction to Borpeta district. Here. Patasar Kusi also to Borpeta. Bozali to same.
RTR बरपेटा बोजाली recently
This is under Bhawanipur Gram Panchayat, Borpeta Jila Parishad,
Yeah.
Bozali Jila Parishad. So
Bozali होगा Bozali दादा ही चलो दादा ही जाने को कल दादा
Bozali, Bozali. Open to click. Capturing our. Date to be 21st. On or before 21st of June. Notice in this case was issued on 18/12/2017. Registry received the relevant records from the foreigners tribunal. 7 forfeited. What's called for by interim protection interim bail 18/12.
हमारा रेस्टोरेंट यहाँ पर ये ना से कैप्टिक तो अपन तो दिखते हैं मुझे टिकट का टिकट हाँ
rule hearing to appear before the Superintendent of Police Quarter, Borpeta, on October 21st for capturing her. Picture.
রুল ইস্যু করছে বিয়ের করবো দিচ্ছে বায়োমেট্রিক
Is it clinic?
হিয়ারিংও দেখবো
A notice in this case was issued on 21/12/2017. Received the relevant reports. Finance Tribunal, Borpeta 10. Interim protection, interim bail, 21/12.
তাহলে হলে
For capturing these. 21st. Notice in this case was issued on 20/12/2016. Registry received the relevant records from the Finance Tribunal. Interim protection, interim bail, 2012. Rule hearing to appear before the Superintendent of Police Quarter for capturing her condition.
I'm extremely sorry, I missed the item number 20, madam.
20.
Yes, madam.
Thank you. Notice was issued on 16/12/2017. Registry received the relevant records. Okay. Finance Tribunal protected her. Relevant picture.
Correct.
We have 21st. Capturing these. None appeared for the petitioner and for the name of two counsels have been reflected in the document. Mr. Sharma, Debasis Bhattaji
Yes,
is there in the court.
I have no idea. I think the বর্তমানে সুচিত্র দত্ত। সেটা ঠিক।
The name of two counsels have been reflected in the petitioner is in reflected in the case in 2012. List on. Testing. Maybe notice in this 22nd. Notice to non-effective. Notice in this case was issued on 03/01/2018. Registry authority received the relevant records for the foreigners. Roman Prick, Karimghanj, interim protection, interim date, 03/01. Rule clearing. Notice in this case was issued on Q1/2018. Likhit है again. Interim protection, interim bill. Rule clearing. If we have postponement of click order, Pacha, Silsa. Sorry, frame. On or before 21st for capturing her. List. Notice in this case was issued on 29/01/2018. Registry received the relevant records from the foreigners tribunal, Nagaon, court number 7, block of Hojai. Interim protection, interim bail, 29/01/2018. Rule. Hearing. To appear before the Superintendent of Police border. Hojai, on or before 21st for capturing her biometrics. condition for
Lordship, kindly the matter may be passed over for the day.
notice in this case was issued on 19/2/2018. Registrar will receive the relevant records from the Finance Tribunal for Prajar. Interim protection, interim pay. 19/2/2018. Rule hearing to appear before.
Also, Lordship.
Order for Prajar on or before 21st for capturing heart. Biometric.
Lordship, a small prayer. Kindly the name of the engaging counsel may be reflected in the cause list. Mr. K. Borua.
Registry shall reflect the name of Mr. K. Buru. Counsel for the petitioner.
I will reply. Please, Your Lordship. Lordship, I have a small prayer, Your Lordship. I may be granted liberty to file additional affidavit to bring in record the exhibited documents, Your Lordship.
Here,
Yes, Your Lordship. Lordship, because the son was declared Indian by the same tribunal and he has produced the same exhibited document which has been exhibited by the father, Your Lordship. Father has expired, Your Lordship. We have substituted him, Your Lordship.
just a minute. What is the name of the son?
Son is Sohar Ali, Your Lordship, Annexure 3, Your Lordship.
How many children he had? How many children?
Lordship, they are well, Your Lordship.
12 to
Sons
13.
and daughters, including
12 or 13.
1, 13, Your Lordship.
13 children.
Yes, Your Lordship.
Now, who has been declared?
Lordship, Sohar Ali, Your Lordship.
Give us the case number. Do you have the copy of the order?
Yes, Your
Give
Lordship.
it to us.
We have annexed it in the petition as well. Annexure 3.
So why need to have a filing additional affidavit? There is a difference.
Yeah.
Son claimed that his father is Chand Mia Sheikh and Zamir Ali was his grandfather. Whereas in the present case, the petitioner claimed that his son Mia Ali and that his father's name is Domer Ali. Addresses the case of the petitioner is Mohanpur Reserve, whereas the case of the son, as alleged by you, is Mohanpur Char. One is shore area, one is reserve. That's the difference. Anyway, notation this case is issued on 16/3/2018. Registry already received the relevant set report of BNCN of the FT public case number 1043 of 2007 from the foreigners tribunal number 5 that was called for by order 16/03/2018, as well as the records of BNCN application number 719 of 2007 from the foreigners tribunal Bongaigaon number 2 of Bhayapuri was called for by order dated 8/07/21. Petitioner is interim correction and interim date. Then 16/3. Issued the matter for hearing later. Another.
Authorize the-
May I please look at? Also, here we have challenged the order of the Varnas Tribunal number 2 in FT case number 146 of 2012. Notice was issued on 14/5/2018. And Lordship, in the order dated 14/5, Lordship, the LCR was called for. It is the case number has been reflected 145 of 2012. Subsequently, we have filed a IA, and then it was corrected, Lordship. It could be actually FT 146 of 2012, Lordship. But Lordship, in 19/4, Lordship, in the order, Lordship, it was reflected as FT case number 145. It appears that LCR has been received, but whether the LCR of 146 or 145 has been received.
Notice in this case was issued on 14/05/2018. Registry already received the relevant records of FT case number 146/2012 from the Fairness Tribunal, second Nagaon, relating to the petitioner that was called for. Petitioner is interim protection and interim bail since 14/5/2018. Will carry to appear before the Department of Police order, Nagaon. This will be Nagaon or in Karbi Anglong.
Lordship, part of the voter also is in the Karbi Anglong, and part of the part is in Nagaon. They are appearing in Kosua police station. From part in West Karbi Anglong and from part of West Nagaon.
Just a minute.
Look.
So original report. Mr. Sharma, just find out whether the petitioner could prove his father, Manindra Singh, or not.
And
Say, not required, because the proceeding tried to project that his father, Maninder Sindra Sil,
Yes.
his name was registered.
year 1954.
So there is a difference and a big difference.
Yes.
In the 1970 voter list, the petitioner shown himself to be a voter from village Niz Kotiatoli, 92 Jamunamuk LSC.
Yes, sir.
But that person, Maninder Chandra Sil, at 1970, was son of Horisaran,
Yes, Lord.
as at about 39 years.
Yes.
Whereas the person who registered Maninder Chandra Sil
Yes.
was the son of Madan Mohan Sil and was 54 years.
Yes, Lord.
And it was in 1965, he was 54 years.
Hmm.
And he is a man of 1970 in a different village.
Yes.
So necessarily not trustworthy.
After 1970 to 2016, Lordship, there is no document. 2016, Lordship. 70 to
In
2016,
fact, the wife name is also wrong.
Lordship.
Lordship,
That
initially,
Maninder Chandra Sil's wife is Meena Rani Sil.
Yes.
Whereas in the voter list of 1970, the petitioner placed before the tribunal is Sarubala.
Yes.
That's why the tribunal did not accept
Okay.
it.
initially they were Lanka. Subsequently, they came to the Bota Lanka. Lordship.
Data protection in frame page 1456. Went to police voter. No, on of before 28 for capturing it. But the rule are getting to it.
Deeply.
Do you have the copy of the decision of your brother? Do you have? Notice in this case was issued on 18/5/2018. And the petitioner is interim protection and interim bail since the said date, 18/5/2018. So the records of Lakhimpur FT1 case number 307/2010 was called for by orders at 18/5/2018 as well as 19/4/2024. Office note reflects that the said record is yet to be received from the registry, received by the registry. Failure on the part of the Fairness Tribunal, first Lakhimpur, not Lakhimpur, to provide the records of LFT1 by Lakhimpur Fairness Tribunal 1 case number 307/2010 decided on 09/04/2018 by the negate fixed. The court shall consider to pass consequential order against the erring officer, including the member of the Fairness Tribunal concerned. The Mr. Sharma or Mr. Payang, one case which relates here, the orders it reflects, but we do not know when it was decided. That relates to one Shankar Devnath, the brother of the proceeding, who has been declared to be a Indian and not a foreigner in fact. That case is LFT case number 47/2010 and district number is 595/07.
But this
But
is,
when- which tribunal we do not know. The Superintendent Police Border as well as the Deputy Commissioner Border, Lakhimpur, not Lakhimpur.
my lord,
Lakhimpur,
in
not
this
Lakhimpur,
case, my lord, some issues are there. It's Jibon Devnath, my lord.
shall also do the needful to provide with the records of Lakhimpur Fairness Tribunal case number 47/2010 arising out of district number 595/2007 of one Sri Shankar Devnath. Before the next is fixed. List on 26th June. Copy of this order be furnished to Mr. J. Payang, Standing Counsel, Home Department, as well as Mr. P. Sharma, Additional Senior Government Advocate, Assam, for their honored communication to the Fairness Tribunal, Lakhimpur first. The Superintendent Police Border, Lakhimpur, not Lakhimpur, as well as the Deputy Commissioner, Lakhimpur, not Lakhimpur, respectively.
My lord, may I submit something in this case, my lord. What I have the information, my lord, probably the letter of earlier order has been sent to the FT1 Lakhimpur. She has informed that, my lord, the case record 307/2010 is of a different person. Probably this letter has been sent, my lord, whether it is there or not, because
307/10 likha,
2010,
arising out of district number 555/07.
307, 2010 is in the name of some Nazima Begum, my lord.
Lakhimpur FT1, case number 307/10. Arising out of district number 555/07, decided on 09/04/2018. State of Assam versus Sri Jibon Devnath. Notice in this case was issued on 1/6/2018. Registry already received the relevant records from the foreigners tribunal second. That was called for by authority 1/6/2018. As well as the order dated 19/4/24. Petitioner is interim protection and interim bail since 1/6/2018. Issue place this matter for hearing on a date to be fixed by the three. Petitioner shall appear before the Superintendent of Police Board
Naga.
on or before 21st June for capturing her biometric ID, fingerprints, and
Public.
notice in this case was issued on 06/05/2019. Registry already received the relevant records of the foreigners tribunal Buxar. Called for by order issued by interim protection interim bail 3. Rule hearing. We have Superintendent of Police Board Buxar on or before 21st. For capturing her biometric ID. No representation on behalf of the petitioner. The name of 5 councils have been reflected in the document. Petitioner is interim protection and interim bail since 8/4/2009. Placed on 5/6. Petitioner is in notice in this case was issued on 21/01/2019. Registry received the relevant records in the foreigners tribunal. First forfeited. Petitioner is interim protection since 21/01/2009. Continue. That's the petitioner that we have. As by the impugn opinion that at 17/09/2018, the learned foreigners tribunal number first forfeited in FP case number 137 of the 2016 opined the petitioner to be a foreigner under the Foreigners Act 1973 of 425/03/1971. He shall appear before the Superintendent of Police order Barpeta nor before 20/06 and say condition. You are also appearing in 37.
Yes, Lordship.
Notice in this case was issued in 21/01/2009. To resume hearing. It's a denied or bail denied. Have a notice issued on 21/01/2019. Registry with the relevant records of the foreigners tribunal number of interim protection 21/01/2009. Hearing prepare for the police order around or the for its weight. Okay. But conditions that capturing item.
Never blessing.
Notice in this case was issued on 11/03/2019. Registry received the relevant record from the foreigners tribunal number 10 Kotali Pachal. That's very in opinion. Dated 27/08/2015 passed by the learned member of Fairness by the Fairness Tribunal number 10 Barpeta in application number 328/2017. Were declared to be a foreigner under the Foreigners Act 1946. Of post 25/03/1971. He shall appear before the Superintendent of Police order Paksa on or before 21st or her. The पहले rule hearing present.
Okay.
Notice in this case was issued on 21/01/2008. That is to receive the relevant records from foreigners tribunal in Kolkata. That was called for by order dated 21. Petitioner is interim protection. The order dated 21. As the petitioner has been declared to issue rule. As the petitioner has been declared to be a foreigner under the Foreign Act 1946 of post 25. She shall appear before the of police. Mr. Ali, it is in Buxa or in Borpeta?
My lord, Borpeta, my lord.
Here,
Tribunal is at Borpeta, my lord.
tribunal is in Borpeta.
Lordship.
Borpeta. What are they?
Now,
You rule it. Eric.
um,
You appear before the Supreme Police Border Borpeta
Borpeta, my lord.
on or before 21st for your bail and
Okay.
capturing your biometric. Notice in this case was issued on 21/01/2019. The registry already received the relevant records from the foreigners tribunal number 1 Borpeta. Petitioner is interim protection since 21/01. As by the impugn opinion dated 04/09/2018, passed by learned foreigners tribunal number 1 Borpeta in case number 341 of 2016. The petitioner has been declared to be a foreigner that of foreigner 1956 of post 25/03/1971. He shall appear before the Supreme Police Court of Borpeta on or before 21st for his bail present chapter 18. उससे पहले रूल कर तैयारी
My lord, I am fed up with utmost respect. I tried my level best to contact with my client, but whether he is alive or not, I do not know, my lord. At least 3 weeks time may be given. He was ill too much last time also.
by order dated 02/08/2000 02/08/2019. The court called for the records of FT case number 2621 of 2021, sorry, 2621 of 2002 from the Foreigners Tribunal, Dibrugarh, wherein by the impugn opinion dated 09/09/2005, the petitioner was declared to be the foreigner under the Foreign Act 1946. But till office notes reflect that till that the records of the said FT case from Dibrugarh Foreign Tribunal, Foreign Tribunal Tinsukia has not yet been received. Foreign Tribunal Dibrugarh,
Foreign Tribunal Dibrugarh, my lord.
Foreign Tribunal Dibrugarh. Foreign Tribunal Foreign Tribunal Dibrugarh. সেই সময়ত ডিব্ৰুগড়ত আছে পাছত just Polpoti record the Foreign Tribunal case 2621 of 2002 arising out of PE number 3033 of 1999 that was disposed of by the Foreigners Tribunal Dibrugarh on 09/09/2005. Okay? The registry shall issue reminder to the Foreigners Tribunal Tinsukia as well as the Foreigners Tribunal Dibrugarh for the records of said FP case number 2621 of 2002 arising out of PE number 3033 of 1999 decided on 09/09/2005 by Foreigners Tribunal Dibrugarh. Placed on 26/6 copy of this order. We furnish the point of Mr. J. Payang, extending council county part. For the not communication to Foreigners Tribunal Dibrugarh as well as Foreigners Tribunal Tinsukia. And also the Supreme of Police order Tinsukia.
With your lordship.
Mr. Payang,
My lord.
this is your case.
Yes. But in this case, I may be given 1 week's time, I'll get the instruction what is exactly going on.
There's a specific order, you remember, due to non-appearance of the parties. Some of the tribunals are just like in the criminal proceeding.
Filed the,
Filed. Here is also a case filed
yes, those, my lord, later on by this honorable court directed the
to reopen. and
reopen
pass-
all these
right.
cases. Probably these matters may be open. Let me get instruction in this case, my lord, but next week,
See, the matter is pending since
2019.
2019.
But
The order was passed on 2020.
Yes. What date, my lord? I'll get it.
By an order dated 10/10/2001. Learned Foreigners Tribunal, Second Nagaon. Filed the reference. Due to non-appearance of the parties. No, don't close the reference as filed due to non-appearance of the parties. Pertaining to FT IM written bracket T bracket close T 36 of 1998. At this stage, Mr. Zepang, Standing Counsel, Home Department, praised for a week time to obtain necessary instructions. Prayer allowed. List on 10th of June, Mr. Pang. Notice in this case was issued on 16/3/2021. And also call for the records of FT within bracket 8, case number 666/2016. Arising out of reference, Tezpur within bracket P, case number 571/2005. From the Foreigners Tribunal within bracket 8, Sonitpur, Thelamara. That was decided on 29/05/2017. Wherein the Learned Tribunal, by the order dated 29/05/2017, appoint the petitioner to be a foreigner of post 25/03/19, foreigner under the Foreigners Act 1946 of post 25/03/1971. Office note. The petitioner is also interim protection and interim rate in 16/3/2021. Office note reflects that the relevant records from the said Foreigners Tribunal Thelamara, Sonitpur is yet to be received. Mr. Sharma is here or left? He has will be in Sonitpur only.
Yes.
Issue reminder to the Foreigners Tribunal. Meet Sonitpur at Thelamara for the records of in bracket 8 case number 666/2016 arising out of reference test bracket 3 case number 571/2005. List on same reports. Copy of this order also be furnished to Mr. G. Sharma, Standing Counsel from the party, for his onward communication to the Foreigners Tribunal 8 Sonitpur, Thelamara, as well as the Superintendent of Police Border Sonitpur. Notice in this case was issued on 16/3/2021. Maybe already Case number FT 14/8 case number 669/2016 arising out of reference test code 14/B case number 573/2005. So interim protection, interim bail since 16/3/20. Okay. इसका number one more by a decision of the opinion by order dated 11/5. Mr. Sharma, same tribunal. Based on 24, some order.
Would you? May I please, your lordship. Lordship, as per instruction, lordship, the petitioner has already been diagnosed. The petitioner has already been diagnosed, as per my instruction.
Do you have the death certificate?
Yes, lordship, and therefore I need 2 weeks.
When
time
did he expire?
About 1 month ago, lordship. So I need some time to collect that death certificate.
Mr. M.S. Alam, learned counsel appearing for the petitioner. During the deliberation, the matter submitted that the petitioner / proceeding Srimati Ajena Bibi, Azena Bibb, daughter of late Kadir Ali, alias Kadir Baksh, wife of Serbar Ali, Serbar Ali, village Alamganj, Part 4, police station, Gauripur district, Dhubri, had expired during pendency of this petition. In view of the event, place this matter on 14th.
After it, lordship, after 20, lordship, if it is possible.
On our list this matter on 26.
Yes, lordship.
06/2024, enabling Mr. Alam to place the death certificate of the petitioner.
Obliged.
We'll take it up at 2 o'clock. It will take some time.
Understand, lordship has kept some habeas corpus matter at 2 o'clock.
No, not today. Not today.
Well, at 2 o'clock already matter is fixed. I'll not take long, my lord. I'll just take about.
On last day, we wanted to.
I'll distinguish that judgment.
No.
I brought the judgment. That was a case of probation, my lord. That was a case of probation.
No, okay. In your absence, that day we indicated, which Mr. Doctor also.
My lord, before, can I just point out one thing, my lord?
Yes, yes.
They say in the impugn order that they have invoked clause 9 of the agreement. Now, which is that agreement where I put my signature, where there is a clause 9?
No,
My lord, in a similar litigation, they have filed affidavit, my lord. If your lordship may kindly have a look. They have filed an affidavit where they admit that there is a model code of contract where our signature does not appear.
no, not only that, one particular thing has been pointed out to Mr. Doctor,
Yes.
and
Well, I'll place the judgment also. If your lordship would kindly come to page 49 of this affidavit which they filed in the other case. Page 49.
similar issue.
Same, my lord.
How many of such persons have been terminated? By the Panchayat department?
About 20-25 cases are there, my lord. No, acha hai na?
Not 20-25, my lord. It's 10-15 matters.
They are all involved in.
Not for this only, my lord. On entire Assam. Different cases.
Different cases, but for the same incident.
Not same incident. Different incident, different cases.
No, but end of the day, they invoke clause 9. But kindly see, my lord.
Yes.
Issue is.
Now, this page 49, nobody's name is there. It's a model. It's a model contract.
Hmm.
So if in a particular contract I have not put my signature, how that contract can be binding on me?
That is because that is not the issue here.
Yes, yes, my lord.
No, they say in this case, clause 9. Please come to impugn order, my lord. Page number 44. Same clause 9. Kindly see, my lord, whereas it has been reported by CO
Yes, you have
Dhemaji
seen
Jilla.
clause 9,
Yes. Subpara.
contract agreement.
It may in persons of clause 9. Now, my lord, the agreement which I signed, that is also there. That is at page 32. The signature, the contract which I signed, page 32, non-disclosure of information. So where is that clause 9 where I put my signature? In fact, my lord, in the other case, court wanted to know that which is that contract from where you derive the power of termination. Then they, my lord, they annex this document in that case where they say it's a model contract. But that model contract we never signed.
No, Mr. Chaudhary,
My lord.
like here in clause 9,
Yes.
we have also read here the clause 9
Yes.
at page 32,
Yes.
as well as clause 2 at page 31.
Yes, my lord.
Now, we asked Mr. Datta, where is that particular clause that he could be terminated by paying 1 month's salary?
Yes.
Mr. Datta said, in this particular agreement, it is not there. So that itself, because we do not know on the basis of which agreement it was available before the learned single judge.
Yes.
He passed that order.
Yes.
So in view of non-availability of that particular clause before the tribunal, and as the department have failed to place any written agreement between the petitioner, the appellant,
And the department.
we'll refer it back to the tribunal, setting aside that order to consider that.
Yes. That will be better.
Much will-
That can by my lord, but in the present writ appeal, my lord, that is not the main issue, my lord. Their case is there, my lord.
Whatever it may be.
311 not applicable.
We are against the order because basically the petition, the appellant here is against the order of the learned single judge. This way, that way, right? But from when we inquired from you, does not find here, and there is no such agreement, a written agreement between you.
That is
and the-
admitted. At
admitted
present,
fact.
there is no.
And that reason will.
Yes, Lordship will remand the matter back to
Remand
the.
matter for his.
Yes, sir,
consideration.
by setting aside the order. Yes.
Why should he put it here? That will let me decide it because that clause is missing.
And when the learned single judge in another case has decided in that way.
Leave it to the learned
Yes,
single.
yes.
But it will go to the.
Absolutely.
appropriate
I think that's the most fair, I mean,
My
aspect.
lord,
To do it before the.
my humble submission is that in that point, my lord. Mainly, basically, it's upon the law points, my lord, not factual points, my lord.
We are not
So,
in that. We
my
are
lord,
not deciding on the that issue now. What
because
we
they have-
found that, you see, basically the order of the learned single judge.
my lord. That I have read, my lord.
Right.
Yes, my lord.
His lordship has come to the finding that page number of 54 para 10. Page 54,
Yes,
Yes,
para,
para 10.
Yes, my lord.
Where is that 1 month's notice and giving that thing? Because you read clause 2 on that day, Mr. Doctor,
My lord,
that clearly reflects that you have to give notice.
my lord.
If you read the clause 2,
That salary part was not there.
salary part is not there and you have to give notice. If otherwise not terminated. If you terminated, Mr. Chaudhary, kindly read clause 2 of that agreement. It will be very clear.
yes, yes.
Supposed to give notice.
But my lord, my
But-
answer will be,
Page 31.
we didn't involve the clause 2 in this particular
You
case,
did
my lord.
not. Now clause 9 doesn't say anything.
That was a
You have not
inadvertent
placed-
mistake, my lord, because
See, basically, in the order by which the petitioner was terminated, the appellant was terminated, was on the basis of clause 9 of the agreement.
My lord,
But
public
there was
order,
that
MS Gill,
particular
my lord,
contract.
public order publicly made. Now my learned friend cannot give any explanation.
That was a, my lord,
Yes.
inadvertent mistake, my lord. For that, I'll place one
Basically,
judgment.
that particular agreement signed between the parties was
Hmm.
not before the learned single judge.
Yes,
They have annexed it, my lord.
Where is that agreement?
yes, page 31.
Agreement annexed.
Which date?
That part is not there, my lord.
That
That
is what,
salary part, my lord.
that is not only that, that's clause 9.
Clause, that is
Doesn't say
inadvertent
anything.
mistake, my lord. Because of the wrong mentioning of the clause, my lord, it did not make the entire thing
Will
invalid, my lord.
let the learned single judge decide.
Decided definitely.
What Mr. Ken Chaudhary learned senior counsel. Hearing for the length slash. Also heard Mr. Ratnaswala, training of the PND department for the respondent number.
Except 5, I am appearing for all, my lord.
1, 2, 4
And 6.
and 6, as well as Mr. P and P Sharma. Learned additional senior correspondent. We'll dispose it of in that.
Mal. Deep note.
My lord, that may be observed, my lord, that we will file affidavit, detailed affidavit in that case. Thereafter, that case may be disposed of.
Where?
The single, before single judgment.
We'll not go to that extent.
No, no.
We'll refund the better back. to
Yes,
the
yes.
learned single
Whatever
judge.
material was there,
Whatever,
yes.
court feels. Why should you get this court?
As lordship is referring,
No, we'll remand the matter back.
Yes.
Fresh consideration or pass a fresh order.
obliged.
Yes, 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 the
Yes.
information you need.
Yes, Lordship, he is appearing before the SP, Border Pujai Lordship, and in every month he is appearing, Lordship.
Why he should appear every month? That
Yeah.
should not be,
Yes, Lordship, but
no, no,
my
no,
instruction,
stop that. Ask him to not to do it.
yes,
Ask the
Lord.
Superintendent Police Board not to impose that.
Mm. But there was no specific communication from SP Border Nagaon.
He is supposed to,
Yes.
because his case is Huzai,
Yes, yes, Lordship.
let it be Huzai.
Hmm?
No.
No, the order was into Pujai for to long term.
Pursuant to our order earlier, passed earlier on 27/05/2024, Mr. Sharma, Mr. G. Sharma, Standing Counsel, Home Department, on instruction submitted that the petitioner is regularly appearing before the Superintendent Police Border Huzai, which is the competent authority in the present case. Though the reference was initially made by the Superintendent Police Border Nagaon, while Hozai was part of Nagaon district. After bifurcation of Hozai from Nagaon district, the present competent authority is Superintendent Police Border in the case in hand. Considering the, to recall the order, it is 0702/2014 passed earlier in the present proceeding regarding the recalling or cancelling the interim order dated 15/5/2020 and 06/01/2022 passed in favor of the petitioner earlier. And the petitioner 70 on interim protection granted earlier on. 15/5/2020 and 06/1/2022. Registry already received the relevant records from the foreigners tribunal number 1 Nagaon. That was called for by order dated 15/5/20. Issue rule. Place this matter for hearing on the date. Retain the records.
May please your lordship, my lord, may I say this matter will be taken about Friday, my lord,
On,
Friday, day after tomorrow.
how's your health now? You're better?
Not that well, my lord.
Okay. What do you have to say?
I have no objection, my lord, in fact.
On the prayer of the council for the parties, place this matter on Friday. Oh, hearing. Yes, Mr. Goswami, you're waiting for something after a long time.
That is why.
Okay, we'll come back for 2 after the hearing. Ms. Sodri, please come to page number 10, the written statement.
Written statement, lordship. In this case, what happened, lordship, the petitioner submitted a voter list of 1966 and
Now
70.
we'll come to that. I will come
No.
to that. Come from page number 11.
Lordship. That the opposite party's father's name is Kapasu Sheikh and mother's name is Pulbanu Nessa. And both's name recorded in the voter list of 1966 by serial number 46, 49, house number 15 in the village Keluapara Part 2 and under 43, number Bongaigaon LSC within the erstwhile Gwalpara district, now Bongaigaon district, lordship. So this is annexure 1, lordship, exhibited as exhibit 1. That the opposite party's parents' name also has been included in the voter list of 1970 with serial number 46 and 49 respectively, house number 15 in the village Keluapara Part 2 under 43, number Bongaigaon LSC within the erstwhile Gwalpara district, now Bongaigaon district, a voter list of 1970 annexed herewith as annexure 2, that is exhibit 2, lordship. That the opposite party had married with Noor Ali in the village Keluapara Part 4, and accordingly her name recorded in the voter list of 1997 with her aforesaid husband Noor Ali by serial number 320, house number 99 in the village 66 Keluapara Part 4 and under 35, number Abhayapuri South SC LSC within Bongaigaon district. That the opposite party name also included in the voter list of 2010 by serial number 374, house number 99 in the village Keluapara Part 4 under 35, number Abhayapuri South SC LSC within the Bongaigaon district, a voter list of 2010 annexed herewith as annexure 4. That on perusal of aforesaid documents annexure 1 to 4, it is evident that the opposite party is a bona fide citizen of India. Her father is a citizen of India. There are some typographical mistake, lordship. The
Now,
opposite,
from the reading of this itself, this 4 paragraph, just tell us which is the link document to prove that she is the daughter of Kapasu Sheikh. Which is
lordship,
the link document?
lordship, 66, 70 voter list showing her father and mother's name.
That's
lordship.
right.
And mother adduce evidence as DW2, lordship.
That is why I want to know from you
Yes,
as
lordship.
DW2.
Lordship.
Let us see.
Lordship, I have not annexed the
We
statement,
have the
lordship.
record.
Lordship, in the record, Serial করিবা exhibit. And lordship, the judgment order itself stated that later on she produced one land document, lordship. That
Go to that.
lordship.
Now, read the evidence of the proceeding.
Evidence in 6 to 9.
Do you have the,
May I read the DW2, lordship?
you read DW1, then DW2 in vernacular.
Lordship,
You'll be
that-
able to read the vernacular?
lordship, I can read, but lordship, the DW1 I have, lordship, DW1 I do not have with me.
You want to read DW2?
Yes, lordship. DW2 I have, lordship.
Read.
মই ফুলবানু নেচা স্বামী স্বৰ্গীয় কাপাসু শেখ বয়স ৭৫ বছৰ
No, read the evidence, not the affidavit. Before the tribunal. or
affidavit,
deposition. Or
lordship.
deposition.
This is the deposition, and lordship, this is the cross part I have with my with me, that is DW2, lordship.
Read the cross part.
মই ফুলবানু নেচা, লৰ্ডশ্বিপ। স্বামী স্বৰ্গীয় কাপাসু শেখ বয়স ৭৫ বছৰ, জাতি মুছলমান, পেচা গৃহিণী, সাংস্কৃত্য। মই ওপৰলিখিত ঠিকনাৰ এজনী স্থানীয় বাসিন্দা হওঁ। মোৰ আনুমানিক ৬০ বছৰ আগত কাপাসু শেখৰ লগত সামাজিকভাৱে বিবাহ হয়। বিবাহৰ পিছত মোৰ নাম স্বামীৰ লগত ১৯৬৬ চনৰ ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হয় আৰু চিৰিয়েল নাম্বাৰ ক্ৰমে 46, 49, হাউচ নাম্বাৰ 15, আণ্ডাৰ 43, নাম্বাৰ বঙাইগাঁও, LA in the village, খেলুৱাপাৰা পাৰ্ট 2, Exhibit 1 is the voter list of 1966. মোৰ নাম 1970 চনৰ ভোটাৰ তালিকাত মোৰ স্বামীৰ লগত লিপিবদ্ধ হৈ আছে। Exhibit 2 is the voter list of 1970. মোৰ স্বামীৰ লগত ঘৰ সংসাৰ কৰা অৱস্থাত 3জনী ছোৱালী আৰু 2জন ল'ৰা সন্তানৰ জন্ম হয়। ল'ৰা 2জন সৰুতেই ঢুকাইছে। ছোৱালী 3জনীৰ নাম ক্ৰমে কাছিৰন নেচা, হাছিনা খাতুন আৰু বেগম নেচা। মোৰ ছোৱালী হাছিনা খাতুনক 1990 চনত খেলুৱাপাৰা 4ৰ্থ খণ্ড গাঁৱৰ নুৰ মহম্মদ আলী পিতা ছাবেদ আলীৰ লগত সামাজিকভাৱে বিয়া দিয়া হয়। মোৰ স্বামী কাপাসু শেখ আৰু মই জন্মগতভাৱে ভাৰতীয় নাগৰিক হওঁ। সেইমতে আমাৰ ছোৱালী হাছিনা খাতুন জন্মগত ভাৰতীয় নাগৰিক হয়। এইটো সত্য নহয় যে হাছিনা খাতুন বাংলাদেশী নাগৰিক হয়। And she stated before the tribunal, lordships, her statement was recorded on 7/11/2015, lordship. May I read, lordship?
Please.
মই মোৰ ছোৱালীৰ হৈ আদালতত সাক্ষী দিব আহিছোঁ। ছোৱালীৰ নাম হাছিনা। মোৰ বিয়া হোৱা 60 বছৰ মান হ'ল। মোৰ 3জনী ছোৱালী। ছোৱালীৰ নাম ক্ৰমে কাছিৰন খাতুন, হাছিনা খাতুন আৰু বেগম খাতুন। 3জনীৰ বিয়া হৈ গৈছে। হাছিনাৰ নুৰ আলীৰ লগত বিয়া হৈছে। হাছিনাৰ বিয়া হোৱা 25 বছৰ হৈছে। হাছিনাৰ বয়স অনুমান 40-45 মান হ'ব। 1965 চনত স্বামীৰ লগত মোৰ নাম ভোটাৰ লিষ্টত উঠে। তেতিয়া ছুটিৰ মুখতে আছিলোঁ। মোৰ জন্ম চাপৰৰ ওচৰত চিঙাপাকত। মোৰ ছোৱালীৰ বিয়াৰ আগতে ভোট দিয়া নাই। ভোটাৰ আইডিৰ ফটোকপি মই আদালতত দাখিল দিছোঁ। And statement of DW1 I have, lordship.
Just a minute. Yes, please.
Right. মই যি কম সঁচা কম মই মোৰ চৰি DW1 মোৰ দেউতাৰ নাম কাপাচু শেখ মোৰ মাৰ নাম ফুলবানু বেৱা মোৰ দেউতাৰ ঘৰ চুটিৰমুখ গাঁৱত মোৰ জন্ম চুটিৰমুখ গাঁৱত মোৰ দেউতাৰো জন্ম চুটিৰমুখ গাঁৱতে হয় 1966 মেৰ চনৰ ভোটাৰ তালিকাত মোৰ মা আৰু দেউতাৰ নাম আছে এক্সিবিট 1 ভোটাৰ লিষ্ট অফ 1966 মোৰ মা দেউতাৰ নাম 1970 চনৰ ভোটাৰ লিষ্টত আছে এক্সিবিট 2 1970 ভোটাৰ লিষ্টৰ কপি মোৰ নুৰ আলীৰ লগত বিয়া হয় 1997 চনত মোৰ নাম মোৰ স্বামীৰ লগত অন্তৰ্ভুক্ত হয় এক্সিবিট 3 উক্ত ভোটাৰ তালিকাৰ কপি 2010 চনত মোৰ নাম ভোটাৰ তালিকাত উঠে এক্সিবিট 4 উক্ত ভোটাৰ তালিকাৰ নকল বৰ্তমান মই খেলুৱাপাৰা গাঁৱত নুৰ আলীৰ লগত সংসাৰ কৰি আছো সত্য নহয় যে মোৰ জন্ম বাংলাদেশত আৰু মই বাংলাদেশৰ পৰা আহিছো মই ভাৰতীয় নাগৰিক হয় মোৰ মা দেউতা ভাৰতীয় নাগৰিক Only discrepancy, Lordship, they stated that they are staying in Sutirmukh, Lordship. When I inquired, Lordship, the OP and her mother stated that in villages they stated Kheluapara as Sutirmukh, Lordship. But in writing it is written as Kheluapara, Lordship. So normally people says that it is Sutirmukh. In that connection they have obtained one certificate, Lordship. This is a document, Lordship, given by Secretary Udupi GP, Lordship. It states that Sutirmukh and Kheluapara, Lordship, almost same, Lordship. As I have not taken any leave from this court, Lordship, so I have not enclosed them. By way of additional affidavit also, I could not bring on record. সেইটো original. Tribunal held that, Lordship, there are some discrepancy in the statement of the DW2, Lordship. She has stated in her oral statement that the OP is 45 years old and OP stated that I am, Lordship, 27 years old, Lordship, in DW1, Lordship.
See, just now you have read about DW2.
Lordship.
Bring it to you for your information.
DW2, Lordship.
DW2, you have said that about 25 years back,
Lordship.
Hasina got married.
Lordship.
And presently she will be around 40 to 45.
So in the year 1990, Lordship. She is she was, Lord.
As per DW2,
yes, Lordship.
in her evidence, she said that she being the mother of the protected mother of the proceeding.
Lordship.
She said that around 25 years back, the proceeding got married, and she'll be around 40 to 45 years.
Lord.
The proceeding DW2 also stated that around 60 years back she got married. Our age, as per our own statement, will be as a DW2, 60 years.
9/9/2015 DW1 statement was taken.
7/11/2015, I'm talking about DW2.
That is DW2, Lordship.
DW2, she said she will be 60 years.
Lordship.
Now, she also stated in deposition that 60 years back she got married.
ছোৱালীৰ নাম হাসিনা, মোৰ বিয়া হোৱা 60 বছৰ মান হ'ল।
Whole, and you just see above, how old is she?
60 years, Lordship.
Now, there in between you will see Hasinar biya hua 25 বছর hoise.
Lordship.
That is in 2015.
Lordship. So her
So,
marriage would be
and
on
then,
90.
Hasinar boyok অনুমান 40-45 মান hobo.
Lordship.
Right? Oh. Now come to DW1.
Lordship.
How old is she?
She is, Lordship, 27 years.
27. But mother is saying that she is 40 to 45 years old.
Lordship. As per her person, Lordship, her marriage was at the age of 1 year, and her daughter's marriage
We are
is
not
also.
on that. See,
Lordship.
see, what we basically were looking for is that,
Lordship.
the tribunal's order,
Lordship.
to what extent it is bad, right? We are only in that extent.
Lordship.
Now, here, she said in 1997, her name figured along with her husband.
No.
We wanted to see the link document between the Prosody and her mother, or Prosody and the father, her father. There is nothing
Lordship.
except the statement of the DW2 saying that the Prosody is my daughter.
Right.
So to rely upon that statement
Lordship.
of the DW2, you just see this is the difference.
Lordship. Some oral discrepancies are there, but Lordship, the OP,
Basically,
Lordship, OP also filed an Jamabandi, Lordship,
now
showing
in the statement of the Prosody or her protected mother, as well as in the evidence in affidavit or in the written statement,
Lordship.
is there any mention of having any land by Prosody's father?
No, Lordship,
you-
that was not
Even if you
stated.
bring in some new documents,
Lordship.
unless it is available in the written statement, how will you make it?
But Lordship, that was,
And that land document, we have seen yesterday. We have
no,
seen
that
land document.
land document was discarded only on the ground that
No, that exhibit 5. Let us see the exhibit 5 that you have also placed.
that is 1966 voter list, Lordship.
No, exhibit 5 is the land document.
Yes, yes, Lordship.
Now, there it is very well written, the remark column. Chakra Bikoyar Tini Soy 2016
Jamabandi,
তাৰিখৰ
Lordship.
নামজাৰি গোচৰৰ such and such mutation number হুকুম মৰ্মে
Lordship.
898 ডাগৰ মাটি মোহাম্মদ কাপাস শেখৰ স্থলত উত্তৰাধিকাৰী সূত্ৰে হাসিনা খাতুন পিতৃ কাপাসু শেখ মাতা কচিৰণ বিবি পিতৃ কাপাসু শেখ মাতা আৰু বেগম বিবি পিতৃ কাপাসু শেখ মাতাৰ নামত নামজাৰি কৰা হ'ল. So, the names of these sisters figured as a legal heir of Kapasu Sheikh. That's how the petitioner tried to
Lordship.
project the
The
case.
3 daughters inherited that plot of land.
Right. Now, where is the statement in the written statement that the Prosody has 2 sisters?
That Lordship, she
And
has,
above this Jamabandi, you see,
Lordship, that was not
this
there, but
Jamabandi, it's very clear. If you see, Kapasu Sheikh, normally what you see in the Jamabandi, how the name of Kapasu Sheikh was entered in the land. It is very clear. Whether that land was purchased by him or he too got it through inheritance We do not know.
For that, lordship, earlier records to be called, lordship.
See, it is the
It is the
proceeding,
proceeding,
it
our
is the
duty,
case of the proceeding who is required to prove her case
lordship,
and nobody else.
lordship. But
Secondly, will you be able to tell us, now coming to the exhibit one,
lordship,
coming to the exhibit one,
that is a 1966 voter list, lordship.
1966 voter list. First of all, it's a translated copy of electoral roll.
Lordship.
It's not a certified copy.
No, this is a certified copy, lordship.
Who certified?
Lordship, election officer, North Salmara, Abhayapuri.
Read section 76 of the evidence. What do you mean by certified copy?
Lordship. Certified copy of public documents, lordship. Every public officer having the custody of a public document, which any person has a right to inspect, shall give that person on demand a copy of it on payment of the legal fees. Therefore, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. Lordship. So there is an,
So how it is complied with section 76 of the evidence?
lordship, it
Mere
was, cer-
signature will not do, ma'am. There has to be the name.
lordship,
We cannot change the act.
but lordship, this is the procedure, lordship,
It is not
they
a
are,
procedure.
lordship,
You are fully aware. That is why
Lordship.
we are asking you. We are fully aware
lordship,
when you purchase a stamp paper,
lordship,
even in the High Court vendor, stamp
lordship,
vendor,
lordship.
if you purchase some this kind of stamp papers from the
Lordship.
vendor, what
Normally,
they will do?
they took our name, lordship.
Huh?
So they enter our name in the stamp paper, lordship.
Stamp paper.
Lordship.
You examine the record.
Lordship, I have seen there
Yeah,
are
examine
so
the
many certified copies of voter list in the Bongaigaon district, lordship. They did never mention the date when they applied, when the copy was
That
ready.
is not required. Just see. That's why you are
Lordship.
saying.
The name they have not written, but they have put their signature, Lord.
Backside, just see the backside,
Lordship.
all blank.
Lordship.
If you see nowadays, not nowadays, even this, that period, particular period, the stamp papers, if you have the inscription inside the stamp paper,
Lordship.
here there is nothing.
Maybe in this. It is
Anyway,
legal.
we
It
are
is
not on
legal.
that.
It is legal.
So how the procedure have proved the link between her and her father,
Lordship. These are the
to
vital
her
doc-
projected mother.
Lordship. Only her mother, Lordship,
Statement,
who
her mother's
adduced,
statement.
yes, Lordship, mother's statement plus Lordship, the 1966 and 70
That is why
voter.
we are asking you, how will you do that the translated copy is the accepted as a certified copy? First of all, there is no authority,
But Lordship,
right?
these are,
Either a true copy, it has to be written.
Lordship,
Now,
it has
in other
endorsed
cases, you
that
will-
it was compared by Lordship.
in other cases, you will see
Lordship.
that it is, if it is true copy or certified copy, you always have a seal and everything.
Normally, Lordship, I have seen there are voter lists provided by the respondent authority are always like this, Lordship. They never put the date of application, date of ready, and date of handing over the certified copy, Lordship. Always we have seen that those parts are blank, Lordship. They kept it blank, Lordship. So this is not the lordship wrong committed by the OP or the proceeding lordship. This is
That's
the
why she should have insisted on that, the certified
Lordship.
copy. This is not a certified copy.
lordship, they are poor persons. They, in fact, lordship, they are not acquainted with these legal procedures, lordship. And we normally
See,
apply,
basically, to accept a particular document
lordship.
as a piece of evidence, we cannot go beyond the law. If you can show us that court in exercise of the power of certiorari or the tribunal formulated under the Foreigners Act can also accept the translated copy and electoral roll.
But there is one, also there is an settled principle of law that admissibility of the document or the manner which they have proved that document, that were their objection never raised by the
Is
other
it
side.
required?
Yes, lordship, the respondent,
required?
they are
Is it a
required to.
suit?
No, lordship,
Is it
that
a
I
suit?
agree,
It's
it
not
is
a suit.
burden is
So
on the
it is the
OP.
burden.
That is
If
true.
it is required, then only.
But lordship, when I exhibited this document, there was no
It's not
objection.
required. That is the reason we are asking you once again, whether the translated copy of any electoral roll, which is not a certified copy, may be printed out in a stamp paper. That is why name of the election officer is not there.
But due to the fault of the lordship, the authority, the proceeding may not suffer. She genuinely
We will
applied
not
for
say
the.
anything in this regard. See, basically,
Your lordship may call for a report from
will
the
not-
person.
we
There
will
is,
not do that.
there
We
is a
are
name,
concerned only with the order of the tribunal
there is
and
a,
not
co-
beyond that.
the copy itself shows there is a name electoral registration officer, lordship.
Who is
So
that?
his signature was there, signatured as Hussein, lordship.
Where is that?
And next page, 1970 voter list says signatured AC Sharma. So their names were there, lordship.
That is not the person, that is the originally who is having it.
Lordship.
The certified copy has to be issued by the person concerned. বেলেগ কেছ এটাও নাই তো গুচি গৈছে পুৰণা আছে নেকি উঠিব লগা আছে নেকি
In Bongaigaon district, your lordship will find all like this. In other district, lordship, I have seen the certified copies are given with dates and names and all this, lordship. But I have seen there are so many voter list certified copy
Okay.
obtained by the proceeding lordship. For that, your lordship may ask for an inquiry
We
whether
are not
these
going to do
documents.
that because we are concerned only with the order of the tribunal, not beyond that.
Then your lordship may give me liberty to make the election authority to make party and make an,
That is why we are saying
yes, lordship. That liberty may be granted. In the meantime, I can implead them by way of an IA, lordship. And whether these documents are valid or not, only that authority can verify, lordship.
okay. So your case is that by 1966 voter list and 1977 voter list, you have shown name of your father and mother,
Yes, sir.
and as a DW2, your mother have deposed that you are the daughter of the
Lord.
Kapasu Sheikh and
Lordship.
uh,
Pulvanu
Pulvanu Neta.
Bewa, lordship. And
Yes, Mr. Sharma. Also, you have shown that you have legally, because being
I
a
have
legal heir,
inherited
you
my-
have inherited the land of your father.
Yes, lordship.
Mr. Sharma, please.
Yes, lordship. Lordship, first of all, lordship.
Mr.
translated to-
Sharma will add or Mr. Pang will, anyone, you can do anyone. We have nothing to say. Up to you to decide.
My lord, the very question here is, my lord, even though my
First
lord,
of all, kindly answer Mr. Pang. While these documents were exhibited before the tribunal,
yes,
no queries were made by the tribunal or by the state council. What do you have to say? So that amounts the acceptability of this two or this particular poll voter list.
my lord,
What do you have to say?
this point has been settled by this honorable court times and again, my lord, that this the objection may not be raised at that time, my lord. Even though it is not objected, the documents may not be admissible. If it is, my lord, the contents of the documents will be not taken as admissible, even if as the document itself is not admissible.
So your reply is the contents of the document will not be admissible.
Yes, my lord.
Why?
Because the document itself is not admissible, my lord,
Why? Why?
because this is not a certified copy.
As because the court is saying or
No, 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 my lord, this is settled position. This is settled position, my lord. This issue has come before also. My lord, this translated copy of the certified copy of the voter list were exhibited in numbers of cases in the Honorable Court. And this issue has come up in one case, my lord, WPC 2460/2016.
2460.
Yes, madam. 2460/2016.
2460/2015. Yes.
2460/2016. Isiron Nessa versus Union of India. In that case, madam, page 3, my lord, last part, page 3. No paragraph is written. And firstly started.
Just
Let me kindly see firstly from page 3 last part. In fact, this starts in page
you
4.
read the paragraph first. The read concerned paragraph.
My lord, may kindly see page 5. Page 4 is missing probably in my book. My page 5, my lord. From the first part. Probably page 4 is missing in my copy, my lord.
Page 5, huh?
Yes, page 5, my lord, on the top it is. Electoral rules of 1966 and 70 were questioned. Question for consideration is whether translated copy of electoral rule can be construed as an admissible piece of evidence. Further question is whether the translated copy can be considered as a certified copy and as an admissible piece of evidence. This was the question in that 100. The Black Law Dictionary 6th edition has defined certified copy mean a copy of the document record signed and certified as the true copy of the officer to whose custody the original is entrusted. Section 61 of the Indian Evidence Act deals with the proof of contents of the documents. Contents of documents may be proved either by primary evidence or by secondary evidence. While primary evidence is explained in section 62, section 63 deals with the secondary evidence. As per section 63, secondary evidence means and includes certified copies, copies made from the original by mechanical process, ensuring accuracy of the copy, and copies compared with original, copies made from or compared with the original, etc. Section 65 deals with the cases in which secondary evidence relating to documents may be given. It says that secondary evidence may be given of existence, condition, or contents of the document in the cases mentioned therein from clause A to G. As per clause E thereof, secondary evidence may be given when the original is a public document within the meaning of section 64. Now, section 64 explains as to what are public documents, and section 76 deals with certified copies of public documents. Now, this button. As per section 76, every public officer having the custody of the public document, who is any person has a right to inspect, shall give that person on demand a copy of it on payment of legal fee thereof, together with a certificate written at the foot of such copy that it is the true copy of such document or part thereof. In such certificate shall be dated, subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of the seal. And first of all, this seal, the certification should be there, the legal fees should be paid, everything should be there, Manoj. What is the legal fees paid, when it is paid, and then the certification in the foot of the Manoj certified copy that it is a certified copy of the original, and it should be sealed and signed by the officer with his full name, Manoj. So that who has issued that certificate, it has to be known, Manoj. Such authorized by law makes use of such seal. Such copy of certified shall be called certified copy. So present petition, present documents, my lord, first of all, your lordship will find every public who is
Yes.
Then, my lord, on careful and cogent reading of the aforesaid provisions of the Evidence Act together with the definition of certified copy, we are of the unhesitant view that translated copy like this, my lord, present case, such as Exhibit A and D, cannot be constituted as certified copies and therefore cannot be treated as secondary evidence. So this is not a secondary evidence. This is not a certified copy. This position is further strengthened if we look Exhibit A and D, because there is no certification by the competent authority certifying that extracts are true copies of the original. Exactly same, same situation in the present case. That extract is not there. So that is with regard to certificate copy. Now, there further discussed which can be accepted or not. This is clear that translated copies where there is no certification, these are not certified copies. So this cannot be, this is not admissible, and this is not a secondary evidence also. Now, with regard to objection, my lord, this is again, my lord, another petition on foreigners issues only itself. This is 7669 of 2016, my. Seven six six nine of 2016. Burhan Ali, my. Burhan Ali decided on 8/6/2018. There itself in my lord, para 21.7.
Just a minute. Yes, which para?
Your lordship may kindly see para 21.7 first, my lord. There again the proposition. Therefore, if a 21.7 says, my lord, if a proceeding relies on a voter list, only a certified copy of such voter list or extract thereof would be admissible in evidence. Filing of an unsigned and unauthenticated or uncertified copy of voter list sought to be relied upon as proof of citizenship would not be admissible in evidence. Therefore, we would respectfully disagree with the view taken by the Odisha High Court. That is first point, my lord. Secondly, on that, my lord, 27.1, 27, para 27. That is, the uncertified copy is an inadmissible evidence, inadmissible document. That is at para 21.7. Now, objection on inadmissible documents, my lord, para 27. Para 27 says, my lord, in so far objection as to the admissibility of documents is concerned, if a document is per se inadmissible evidence, if a document is per se inadmissible in evidence, non-raising of objection by the state would not render such inadmissible evidence as admissible. So the document, my lord, which has been produced by the proceeding in the tribunal is per se inadmissible because it is not a certified copy. It is said. So if it is per se inadmissible documents in evidence, non-raising of objection by the state would not render such inadmissible evidence as admissible. So that is clear, my lord. So first of all, my lord, the petitioner relied on two documents, 66 and 70 voter list. Those are not certified copies, and those are not admissible document evidence. So if these two are gone, my lord, there is no other documents of the petitioner, father or mother of the petitioner, to show that they are in India prior to 1970 or 71.
Why 66 and 70 are there?
No, these are not inadmissible documents, my lord. Now, as I have, my lord, read out from the judgment, both this judgment, it is said, my lord, this cannot be admissible evidence. If these documents, these are not admissible at all, so this cannot be taken into consideration. Inadmissible documents, inadmissible evidence. So in absence of both this, if these two documents are discarded, being inadmissible, my lord, there is no other documents to show that the parents are there in India prior to 1971. The first point is that the petitioner has to show that either she or her parents were there in India prior to 1971, 25th of March. My lord. So in absence of, if these two documents are not there, my lord, discarded, there is no evidence at all that parents were there in India. Now presumed, my lord, even though it is not admissible, presumed there were, my lord, Kapoor Sheikh, Kulban Nessa in 1966 and 70. For argument's sake, if we presume that these documents are there, even thereafter, my lord, the petitioner failed to establish herself to these persons by any admissible document. That is the second part. First of all, these two documents are not admissible. Even though we presume for the purpose of argument's sake, my lord, that these documents are admissible there. But the petitioner fails to prove that this person who are there in 1970 and 66 voter list are his parent or her parent. There is no documents at all which were exhibited by the petitioner. She has exhibited 97 voter list, 97 and 2010. 97 voter list, page 14, is of Hasina Khatun, wife of Nur Ali, is of Khelwa Para village, part 4. This does not show that the Hasina Khatun is the daughter of Kapoor Sheikh of 1966 and 1970. No, by no means this document shows any link of the petitioner to the parents. Similarly, page 15, the voter list of 2010 also doesn't provide any link of the petitioner to her parents. That is another point, my lord. And thirdly, my lord, she has given her WS. WS is totally inadequate. WS is totally inadequate. She has not stated anything about her place of birth, date of birth, my lord, which is the requirement in as per para 26 of the Samananda Sunwal 1. Because she has to show, my lord, she is in India and she was born in India. To show that she has to fit, my lord, her date of when she was born, where she was born. She has to show his, show her citizen, show the citizens, prove her the citizenship of her parent, that the parents are citizen of India, or in some cases the grandparents are. What she has, my lord, is she has nowhere stated what is her date of birth, where is her place of birth. When she got married, that is also not stated in the WS. What happened to his parent? What happened to his father? No, that is not stated there. And if she has any siblings, that is also not there. WS, we can see, my lord, at page 10 is the WS. WS, she has said the opposite party begs to above noted cases as follows. There is no cause of action to institute the instant case against the opposite party. As such, the instant case allegations are liable to be dismissed. That the entire allegations made against the opposite party is doubtful and illegal, foreigner, baseless, concocted and defamatory. That is the point number 2. 3. That ensuring opposite party does not admit the contents of the allegation filed by the SP Bongaigaon district. 7. Except those which have been more particularly admitted by this opposite party, there is nothing. That the complainant has not made any proper inquiry regarding the citizenship of the opposite party and whimsically blaming the opposite party. That is in para 4. That the 5, that case is not maintainable both in law and facts. That the opposite party is bona fide Indian citizen, having permanent dwelling, house, landed property, also supporting voter list of opposite party, and also having bona fide Indian domicile. No. That ensuring opposite party being bona fide Indian citizen, furnishing the following documents to establish support of the bona fideness of Indian citizenship, and for consideration of the honorable tribunal. That is point. Then para 8, opposite party's father. First time she has mentioned the father's name, my lord, Kapsu Sheikh, and mother name Fulban Nessa, and both name recorded in the voter list of 1966 at house number so and so in village Khelupara, part 2 under 43 Bongaigaon LAC, within erstwhile Gwalpara district. She annexed the voter list of 1966. The opposite party parents' name also has been included in the voter list of 1970 at the same village. Annexed the 1970 voter list. Then the opposite party had married with Noor Ali in the village Khelupara, part 4. Accordingly, her name recorded in 1997 with her aforesaid husband, Noor Ali, at serial number so and so, so and so. She has not stated, my lord, what is her date of birth, what is the year of birth, where she was born. The opposite party name also included in the voter list of 2010, that is annexed at Annexure 4. On perusal of the aforesaid documents, Annexure 1 to 4, it's evident that opposite party is bona fide citizen of India. This is the, my lord, WS. Totally inadequate, my lord. At least she has to say where she was born. That is the requirement of law, my lord. What is her date of birth? At least year of birth. She was born in sometime this year at this place. To claim citizenship of India, she has to claim that she was born in India. That is not claimed in the WS. In which place she was? My lord, the parents What happened to father? What happened to mother? Nothing has been said in the WS. If she has any siblings, my lord. She said she married to my lord, she was married to one Nur Ali. When did she got married? These are very materials, my lord. Now, only her claim is that, my lord, that from the aforesaid documents, it is evident that the opposite party is a bona fide citizen of India. So her claim is that her father's name and mother's name were enlisted in the voter list of 1966 and 70. Her name is enlisted in 1997 and 2010. So she is a citizen of India. The Honorable Apex Court has said, my lord, long stay and enrollment of the name in the voter list itself is not enough that to show that he is a citizen of India. A person may stay in India for a long time and somehow he may or she may enroll her name in the electoral roll. It doesn't mean she is a citizen of India. She has not said anything more than that. My lord, 2002 4 SCC 346. This is by the Honorable Apex Court. 2002 4 SCC, my lord, 346. This is Anwarul Khan. Here in this case, my lord, Pakistani national, she somehow entered her name in the electoral roll and claimed that as his name is in the electoral roll, entered in the electoral roll, he is a citizen of India, like the present petitioner. Here the Honorable Apex Court has says, my lord, page para 15 in that judgment, my lord. We agree with the High Court that a case for interference with the order of deportation is not made out. Long stay in the country and enrollment in the voter list would not confer any right of an alien to continue to stay in the country. So he is not entitled. So we do not find any infirmity either in the reasoning adopted or the conclusion arrived by the High Court or even by the Government of India in order that it so and so by which the person was asked to deport. That is on my lord, long stay and her name is enrolled in the voter list of 1997 and 2010. On mere dead grounds, she cannot claim that she is a citizen of India. Another issue, my lord, the mother has deposed in this honorable deposed, though it is not here, my lord, it is seen that the mother has deposed before the tribunal. But interestingly, my lord, after the 1970 voter list, there is not a single document of her mother. Neither she has produced, nor mother has produced any documents to show that she is in India after 1970. There is not a single document of her mother. But another aspect, the mother DW2 has deposed, my lord, before the tribunal. The daughter, the petitioner got married in 1990. And from the deposition of DW1, she deposed that, my lord, in 9/9/2015. From the deposition of DW1, it is in, my lord. On 9/9/2015, she was 27 years of age. If she was 27 years in 9/9/2015, her date of birth will be sometime in 1988. If mother is right, that she was the daughter, that means petitioner got married in 1990, it's no way possible, my lord, because she was born in 1988, got married in 90. after 2 years. So these are all material facts, my lord, which contradicts their, my lord, story themselves. And another document, my lord, though it was not exhibited at the time of evidence, at the time of argument. At the time of argument, they produced another, my lord, land document. And that was not exhibited. That was not under process. That was not, my lord, exhibited during the time of evidence. It was not exhibited properly at the time of evidence, even though it was, my lord, produced at the time of argument. And it is marked as exhibit there in the record, my lord. From the record it is seen. But the opinion does not reflect that it was exhibited in time. For that, my lord, the land document was obtained, the mutation was done during the time of pendency of the present, my lord, proceeding in the tribunal. That is also even after the completion of the evidence, my lord. After completion of the evidence, the land document was obtained. And most interesting, most important part is, my lord, she has neither stated in her WS nor in evidence that the mother or the father has any plot of land and which she is acquired by way of, my lord, inheritance. That statement is nowhere there. Suddenly, she become wiser after the evidence is closed. At the time of hearing, that, well, she become wiser and she got the documents and she produced it before the tribunal. That cannot be considered in fact. And the land document is the, my lord, the petitioner, as per the petitioner itself, my lord, the parents belong to, my lord, village Kheluapara Part 2. And they were residents of Kheluapara Part 2. The land documents belong to Kheluapara Part 7, my lord. It's a different village. Kheluapara Part 7. And as I have stated, my lord, neither in the WS nor in the evidence she has stated when did father die. Why I said, my lord, these are important facts, because if she doesn't say that father died in 2000, prior to 2016 or 17, the land cannot be mutated from the father. So it has to be clear, the petitioner has to be clear that when did father die. If father died in 1970, why the land was not mutated for long? And if father died after 2017, the land cannot be mutated in 2016. So the tribunal is not, my lord, aware about all these things. When did father die? How can this, that in absence of those, my lord, evidence, the tribunal cannot accept that yes, your father is so and so and he died on so and so. This presumption cannot be taken by the, my lord, tribunal without any evidence. And it is the settled position law says, my lord, the burden is on the petitioner to produce all these documents, all this evidence to establish her citizenship. So from this, my lord, it is clear the tribunal has committed no wrong while giving the opinion. And as such, this, as under certiorari jurisdiction, your lordship may not interfere the opinion of the tribunal at this stage.
If my learned friend has completed, may I reply, Lordship?
What one? What the kind of the petitioner has placed said that her parents were there in the voter list of 1966 and 70. Well, mere saying will not do, my lord. That's that this honorable court has said, my lord. Para 14 of that judgment, my lord. Para 14 says, my lord, we are constrained to observe that a mere claim by the suspected person by referring to a voter list claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. The claiming will not do much. This is because there is also a further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. Mere claim will not do. That has to be, my lord, substantiated by materials acceptable in law. So here the petitioner says the parents were there in 1966-70. Two persons' names are there. But in absence of any linked document, the claim that those persons are my parents, that will not do much. And secondly, another judgment on the same line, my lord, that is 2019 5 GLR, my lord, 471. Also 2019 1 GLT 784.
Same judgment.
Same judgment.
5 GLR
5 GLR 471.
471.
Yes, ma'am.
2019 1 GLT.
Yes, ma'am.
Page,
my lord, 784. Please, from para 13 onwards. In fact, para, my lord, 10 onwards, it is discussed, discussion is there with regard to section 9 of the, my lord, foreigners, what are the burden, how it is to be proved, my lord. May I read, my lord, para 10 onwards. From reading of section 9, it is apparent that onus of proving the proceedee is not a foreigner or is not a foreigner of such particular class or description as the case may be, say lie upon such person, notwithstanding anything contained in the Indian Evidence Act. In other words, the burden of proof that the proceedee is not a foreigner would lie upon the proceedee himself or herself. In a proceeding under the Foreigners Act 1946, in order to discharge such burden, if the proceedee relies upon a particular given person whose name appears in a voter list of 1966 or 70, or whose name appears in a particular land document pertaining to the said period, or relies upon such other acceptable and admissible document which establishes the existence of such person within the territory of India during the relevant period, that is prior to 25/3/1971, the discharge of burden of proof as required under section 9 of the Foreigners Act 1946 would be that the proceedee concerned would have to prove his lineage to the particular person whose name appears in the aforesaid document pertaining to the period prior to 25/3/1971.
Which paragraph you are reading?
Para 10, my lord. Probably para may
Para
be
10 only.
para 10. Well, probably the para may be differ, my lord.
No, no.
Yes. This is Supreme today para 10. Para 10. Your lordship got it. Then, my lord, it is said that it in para 11, my lord, although section 9 of the Foreigners Act 1946 provides that the onus of providing that the proceeding is not a foreigner would lie upon such person, notwithstanding anything contained in the Indian Evidence Act 1872. But in order to understand the concept of burden of proof, we may still rely upon the concept of burden of proof as provided under section 101 of the Evidence Act of 1872. Section 101 of the Evidence Act of 1872 provide as follows. Whoever desires any court to give judgment as to any legal right or liability depends on the existence of facts which he asserts must prove that those facts exist. This is the most important part. The concept of burden of proof, next, burden of proof as provided under section 101 of the Evidence Act is that whenever whoever desires any court to give judgment as to any legal rights or liability depends on the existence of facts which he asserts must prove that those facts exist. In the case in hand, under section 9 of the Foreigners Act 1946, the existence of the fact which should be required to prove by the proceeding is that the concerned person whose name appear in any of the aforementioned public documents or documents relied upon by the proceeding alone is the lineage of the proceeding. He has to prove that he alone is the lineage of that proceeding person. As a corollary, any evidence being laid to discharge of such burden of proof, we should indicate the lineage of the proceeding to a person merely having the same or similar names as that of the person appearing in the public documents relied upon, in our view, would not be sufficient discharge of burden of proof to establish the existence of the fact that the person named in the referred public documents constitutes the lineage of the proceeding. In order to discharge the complete burden of proof, the nature and purport of evidence must be such that lineage is established not only with respect to the person whose name appears in the public documents relied upon, but at the same time rules out the possibility of it being linked to any other person having a same or similar name. These possibilities has to be ruled out. So this is clear, my lord. The petitioner has brought two documents and said, this is my father. In absence of any, my lord, documents, my lord, directly linking to the parents with the petitioner, the possibility that the person may be differ is not ruled out. So this judgment has clearly said, my lord, on that point. One issue, my lord, as my learned friend may argue again, my lord, that the mother has come and she has given her evidence. So that is enough. What needs more, my lord? But that is settled by the Honorable Court in the foreigners' cases, my lord. I just like to point out one judgment of the Honorable Court where mother came and that was not accepted. That is 1900 of 2019, my lord. One 1900 of 2019, Noor Begum.
Noor Begum.
Yes, madam. WPC 1900 2019. There will be in para 6, madam. Page 4. It is said, the statement of DW2, that is Zahura Begum, who claimed to be the mother of the petitioner, similar in the case matter, cannot be relied upon in the absence of any documents showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, since any documents to support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. That is, my lord, in the murder's evidence. It is clearly said oral testimony of DW2, a claim murder, since documentary support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Similar is the point taken in the matter of another judgment. 4020 of 2017, my lord. 4020 Asia Khatun, and they are in page 3, my lord. Probably it will be also para is not written. In the judgment, second para of the page 3, my lord. There, the projected father appeared and he deposed, my lord. The statement of DW2, that is there, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship with the petitioner. So whether father or mother, they have to come, if they come, my lord, they have to bring some documents, firstly showing their relationship to the son or daughter. Then the oral evidence to support that. That can be acceptable in some cases. But in absence of documents showing their relationship, my lord, the evidence of the parents cannot be accepted. Amiruddin, who claims to be father of the petitioner, cannot be relied
This
upon.
is 4010 or 4020?
4020, my lord. 4020 17, my lord. Para 3, page 3, my lord, second paragraph. The statement of DW2, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship to the petitioner. In this, we would observe that in a proceeding under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. So this is clearly said, madam. Oral testimony is no proof of citizenship. And in this aspect, madam, we have to remember one thing.
Yes, Ms. Chaudhary and Mr. Pine.
My lord, only one point is left, my lord. One point. My lord, well, my lord, considering the evidence of my lord DW2, we have to remember, my lord, neither the petitioner nor the mother has produced any documents of that person, my lord DW2, after 1970. After 1970, there is not a single document of that lady who has come forward for giving evidence as DW2. And last point, my lord, as I have said, my lord, the land document which was brought at the time of argument, at what stage it can be. In that effect, reasonable court has dealt with a judgment, my lord. In fact, in that case, they filed a petition before the tribunal for bringing in new documents after closing the matter evidence. So that was not accepted. That is 2021 matter, 2021 1 GLT 799. Under what circumstance the fact is described in page 3, in para 3 in that judgment. In that case, fact was the learned counsel for the petitioner has submitted that the petitioner is a poor and illiterate lady. Though her engaged counsel, she had filed her written statement and had adduced evidence by examining witnesses. It is submitted that at the time of filing of written statement and evidence, some vital points have been left out, which were not previously known to her. Moreover, some relevant and important documents prior to and after 1970 were in custody of others, and now the documents have been traced out by her. It is submitted that these documents could be produced and viewed and produced at earlier stage, despite due diligence. That was the point, despite due diligence, they could not file it. Now, findings, the decision of this honorable court at para 14, in that judgment. In fact, this honorable court has discussed lots of judgment, numbers of judgment. Para 24, para 14, it is said, in the present case's hand, we find that the petitioner is seeking to introduce evidence by recall of witness, which is already available at the time when defense witnesses were examined. The documents, as indicated herein above, are neither new evidence nor should to be introduced. Indicated herein above are neither new evidence sought to be introduced nor new facts discovered subsequently. But the land, if the father had at any point of time, this is not a new fact. That father had any land in her name, in his name, and she has acquired that land from father. These are not new facts, mother. These are known if it is actually true, and if these facts were existed at that time, this is known to her. She has not disclosed all these things at the time of evidence, nor at the time of written statement. Thus, it apparently no new facts discovered subsequently. Thus, it appears that only after cross-examination of the witnesses, that certain lapses in the evidence on the petitioner's side was noticed. When they noticed the lapses, they tried to bring the documents. In that case, the main purpose of order yes. Order rule CPC order 18 order 18 rule 17 CPC is to enable the court while trying a case to clarify any doubts which it may have with regard to the evidence led by the parties. The said provisions are not intended to use to fill up omissions in the evidence of witness who has already been examined. If one requires any authority on that point, the so-and-so that has been relied on, the petition number. So the point here is, my lord, the new evidence cannot be introduced to fill up the gaps, fill up the lapse. And for that, in fact, if they want to introduce new evidence after closing of the cross-examination, my lord, closing of the evidence, they should file a new application for that under this provision of CPC. But even though even if they file also, then also it cannot be allowed for filling up the laps after cross-examination. The petition number so-and-so was filed under so-and-so of rule so-and-so. In this regard, we find that the said provisions had been repealed by Code of Civil Procedure so-and-so. In the light of the discussion above, we are of the considered opinion that learned tribunal did not act contrary to law while acting the petition. Their petition was rejected in the trial court. But no. Now, my point is that bringing up this point, this the proposition of para 14, once the evidence is closed, even though they produce any documents, that cannot be used for filling up the gaps, lapses of the proceeding. Because it is only the court can ask if court can allow, if for some doubt, clarification of doubt. It is not for the purpose of filling up the lapse. Because the petitioner does not have at any point of time, the petitioner had no documents linking himself or herself to the parents. So to filling up that evidence, to bring that evidence, they had produced the documents at the time of argument. And that is
Anyway, the report particularly has no right to that.
Yes, yes.
Even if it's placed with-
even
right. Now, before you answer, Ms. Chaudhary, just for both of us been discussing for some time, and we are placing something from the record which the proceeding placed before the trial. So I just want to know from you, which is silent in this proceeding, both Mr. Piring and Mr. In the written statement, there is no affidavit except the verification. So there is no such address where the petitioner belongs to. Now, from the records, we have seen the inquiry was with regard to the proceeding who is from Keluapara Part 4. If I'm not wrong. The
Paragraph 10, she mentioned that
having it. Keluapara
Part 4, Lord.
Part 4, but the investigation was with the Keluapara part. Because Keluapara Police Station, Jogighopa, District Bongaigaon.
And Lordship, from the order sheet, your Lordship will find that at the instance of the court, there was an inquiry held.
That we have seen, but
Yes.
if you've seen the again the report, it's very interesting how the police have done it. So it is better not. The Gram Panchayat certificate, voter list of 1966 and 1970, and the ID voter. That was the basis how the police have given the report that the Kapasu Sheikh is our father. Anyway, so there is only verification, there is no affidavit, so the address is not there. Now coming back to the cross part of the proceeding. Please take your seat, Mr. Listen to us, that's all.
Lord.
It was on 9/9/2015. Hashina Khatun, 27 years, daughter of late Kapasu Sheikh, village Sutirmukh, police station Jogighopa, district Bongaigaon. More deuter naam Sorgio Kapasu Sheikh. Mar naam Kul Bhanu Bewa. More deuter ঘৰ Sutirmukh গাঁৱত. মোৰ জন্ম Sutirmukh গাঁৱত. মোৰ দেউতাৰো জন্ম Sutirmukh গাঁৱতে হয়. 1966 চনত মোৰ 1964 চনৰ ভোটাৰ তালিকাত মোৰ মা আৰু দেউতাৰ নাম আছে. Exhibit 1, voter list of 1966. মোৰ মা দেউতাৰ নাম 1970 চনৰ ভোটাৰ লিষ্টত আছে. Exhibit 2, 1970 চনৰ ভোটাৰ লিষ্টৰ কপি. মোৰ নুৰ আলীৰ লগত বিয়া হয়. 1997 চনত মোৰ নাম মোৰ স্বামীৰ লগত অন্তৰ্ভুক্ত হয়। এক্সিবিট 3 উক্ত ভোটাৰ তালিকাৰ কপি। 2010 চনত মোৰ নাম ভোটাৰ তালিকাত উঠে। এক্সিবিট 4 উক্ত ভোটাৰ তালিকাৰ নকল। বৰ্তমান মই খেলুৱাপাৰা গাঁৱত নুল আৰিৰ লগত সংসাৰ কৰি আছো। সত্য নহয় যে মোৰ জন্ম বাংলাদেশত আৰু মই বাংলাদেশৰ পৰা আহিছো। মই ভাৰতীয় নাগৰিক হয়, মোৰ মা দেউতা ভাৰতীয় নাগৰিক। Now, Exhibit 1 and 2. The voter list of 1966 and 1970 of the projected parents of the atrocity or the petition.
Yeah.
That voter list belongs to number 50 Kheluapara part 2 and nothing to do with Sutir Move or Sutirpara, whatever.
Yes.
Nothing, no mention. Now, in the voter list of 1966, Kaposo Sheikh, father's name is Naveen Sheikh, age is not there. Then the Fulbhanu Nessa, husband name is Kaposo Sheikh, female, age is not there. Now 1970 voter list from the number 50 Kelwapara part 2 village, not from Sutir Move. Again Kaposo Sheikh, son of Naveen Sheikh, is 44 years in the 1970. Look at the age of father.
Kapasu Sheikh 44.
And what does his father say? Oh, Naveen Sheikh is not, Nipasu Sheikh is elder brother, I'm wrong. Then Fulbhanu Nessa is 32 years.
32.
Okay. Now listen to the DW2. Entire evidence. That is evidence in affidavit. মই ফুলভানু নেছাৰ স্বামী স্বৰ্গীয় কাপাসু শেখ, বয়স ৭৫ বছৰ, জাতি মুছলমান, পেছা গৃহিণী, সাং সুতিৰ মুখ, থানা যোগীঘোপা, জিলা বঙাইগাঁও, অসম। শপত খাই কওঁ যে মই যি কম সঁচা কম। মই ওপৰৰ লিখিত ঠিকনাৰ এজনী স্থানীয় বাসিন্দা হওঁ। মোৰ আনুমানিক ৬০ বছৰ আগতে কাপাসু শেখৰ লগত সামাজিকভাৱে বিবাহ হয়। বিবাহৰ পিছত মোৰ নাম স্বামীৰ লগত 1966 চনৰ ভোটাৰ তালিকাত অন্তৰ্ভুক্ত হয়। মোৰ চিৰিয়েল নম্বৰ ক্ৰমে 46, 49, হাউচ নম্বৰ 15, আণ্ডাৰ 43 নম্বৰ বঙাইগাঁও, LA in the village, Kheluapara part 2. Exhibit 1 is the voter list of 1966. মোৰ নাম 1970 চনৰ ভোটাৰ তালিকাত মোৰ স্বামীৰ লগত লিপিবদ্ধ হৈ আছে। Exhibit 2 is the voter list of 1970. মোৰ স্বামীৰ লগত ঘৰ সংসাৰ কৰা অৱস্থাত 3জনী ছোৱালী হয় আৰু মই 2জন ল'ৰা সন্তানৰ জন্ম হয়। ল'ৰা 2জন সৰুতে ঢুকাইছে। ছোৱালী 3জনীৰ নাম ক্ৰমে কাছিৰন নেছা, হাছিনা খাতুন, বেগম নেছা। মোৰ ছোৱালী হাছিনা খাতুনক 1990 চনত খেলুৱাপাৰা 4ৰ্থ খণ্ড গাঁৱৰ নুৰ মহম্মদ আলী, পিতা জাভেদ আলীৰ লগত সামাজিকভাৱে বিয়া দিয়া হয়। মোৰ স্বামী কাপাসু শেখ নাম সম্পৰ্কে থানাৰ পুলিচ আদালতত নিৰ্দেশ মতে যোৱা ৭/৬/2014 চনৰ তাৰিখত প্ৰতিবেদন দাখিল কৰিছে। মোৰ স্বামী কাপাসু শেখ আৰু মই জন্মগতভাৱে ভাৰতীয় নাগৰিক হওঁ। সেইমতে আমাৰ ছোৱালী হাছিনা খাতুন জন্মগত ভাৰতীয় নাগৰিক হয়। এইটো সত্য নহয় যে হাছিনা খাতুন বাংলাদেশী নাগৰিক হয়। This is her evidence in affidavit now in cross or being inquired by the court what she had said. নাম ফুলভান খাতুন. Earlier she did Fulbhanu Nessa. Now this time she is saying Fulbhan Khatun. স্বামীৰ নাম স্বৰ্গীয় কাপাসু শেখ, বয়স ৬০ বছৰ, গাঁও সুতিৰ মুখ, থানা যোগীঘোপা, জিলা বঙাইগাঁও। মই যি কম সঁচা কম। মই মোৰ ছোৱালীৰ হৈ আদালতত সাক্ষী দিব আহিছোঁ। ছোৱালীৰ নাম হাছিনা। মোৰ বিয়া হোৱা ৬০ বছৰমান হ'ল। মোৰ 3জনী ছোৱালী। ছোৱালীৰ নাম ক্ৰমে কাছিৰন খাতুন, হাছিনা খাতুন আৰু বেগম খাতুন। 3জনীৰ বিয়া হৈ গৈছে। হাছিনাৰ নুৰ আলীৰ লগত বিয়া হৈছে। হাছিনাৰ বিয়া হোৱা 25 বছৰ হৈছে। হাছিনাৰ বয়স অনুমান 40-45 মান হ'ব। 1965 চনত স্বামীৰ লগত মোৰ নাম ভোটাৰ লিষ্টত উঠে। তেতিয়া কুটিৰ মুখতে আছিলো মোৰ জন্ম চাপৰৰ ওচৰত টিঙাপাকত মোৰ ছোৱালীৰ বিয়া আগতে মোৰ ছোৱালীয়ে বিয়াৰ আগতে ভোট দিয়া নাই মোৰ ভোটাৰ আইডেন্টিটিৰ ফটোকপি মই আদালতত দাখিল দিছো now the proceedee as well as proceedee's projected mother very specifically mentioned that they were and are particularly the parents at village Sutirmukh.
Sutirmukh.
There is no mention that they were in the in the village number 50 Kiloepara part 2. Now the proceedee's projected mother have also reiterated the fact that even at the time of the voter list, when there's name figured in the voter list of exhibit 1 or exhibit 2, they were at village Sutirmukh.
Sutirmukh.
Now, voter list belongs to number 50 Kiloepara part 2. The proceedee DW2, the proceedee's mother, have given a photocopy of the
Voter identity.
EPIC,
Yes.
where her name, we don't know whose name it is. Husband name is Kapasu Sheikh. It's not late Kapasu Sheikh. It is Kapasu Sheikh. And the name figured is Purbhan Bewa, Furbhan, Offamiyat Purbhan. Now, that is, initially she said in the Pulbhanu Nesa, then in the cross she said she is Pulbhan Khatun, and the voter ID is Purbhan Bewa.
Beva,
Whereas the
Beva is because her
we
husband.
don't
died.
know when a person dies in the
Yes.
Muslim community, it is Bewa. Nowhere it is the Pulbhanu. So difficulty is, these are the things which we have found from here. The proceedee said it is Pulbhanu Bewa. Then the proceedee herself in her evidence in affidavit said she is Pulbhanu Nesa. And during her cross or the questions made by the tribunal, she said she is Pulbhanu Khatun. And she has deposited or submitted her EPIC that belongs to one Purbhan Bewa from
Kiloepara.
145 Kiloepara part 2.
Yes.
We don't know which one is correct. Because all along, the case of the proceedee before the tribunal as well as that of the DW2 projected mother, that they are from village. Exhibit
Kiloepara
1
part
and
1.
2. Forget that it's a certified copy or not a certified. Belongs to number 50 Kiloepara part 2.
Part 2 and she married to Kiloepara part 4. Then
That
I
marrying is not the
Yeah.
thing.
But then
So-
I inquired, Lottie, why you both of you are again and again saying Sutirmukh, Sutirmukh. Then they stated before me that normally the village people say that part as Sutirmukh, Lordship. The ending river portion was there, Lordship. So normally the village people call it Sutirmukh, Lordship. But
See,
in-
Ms. Chaudhary,
Lordship.
evidence before the tribunal, what kind of evidence?
In written, your Lordship will
See,
find
evidence-
everywhere
See,
Kiloepara
first
part
of
2.
all, you have to see, it has to be reliable, trustworthy,
That is
and acceptable.
Lord.
We have shown you how it differed.
Lord.
That's
Only Lordship
Yes,
is
now
that,
your
that
reply.
is oral evidence, Lordship. The documentary evidence says, Lordship, she is a resident of Kiloepara part 2.
Okay, what is your reply?
And
Ultimate.
Lordship may kept it part her
No.
some other
Just
day,
reply, we are
Lordship.
finishing it off.
Lordship, then I have to rely on some judgments, Lordship, which says, and my learned friend objected to the contention that his contention is that, Lordship, after closure of evidence, we have exhibited that document, Lordship, land
Don't
document.
go on that. What is available before us will be on that. Will
Yes,
not go
Lordship.
beyond anything.
And without taking leave of the court. But Lordship, there is
We are
an
not on that.
additional
We are not.
evidence in chief submitted by the DW1 and accordingly that land document was submitted, Lordship. And in regard to Jamabandi, Lordship, there is a decision of this court that is WPC. WPC 2131 2018. I have two copy, Lordship.
We'll get it, 2131, 2018.
2018.
Hmm.
In paragraph 36, Lordship.
What is the finding?
As regards Exhibit 12, which is a certified copy of Jamabandi, it has been ignored by the learned tribunal primarily on the ground that the proceedee had not submitted the land purchase document of the said land or the mutation order for transfer of ownership from the original pattadar, and also that he had not stated in his written statement when he filed on receipt of the summons. The tribunal also observed that the proceedee did not mention in his affidavit as to when his projected father had purchased the land. However, we are of the view that aforesaid reasons cannot be good grounds to ignore the said document for reasons which are discussed hereinafter. So, Lordship, the similar to my case, Lordship, same objections were raised by the respondent authority, Lordship, in regard to that Jamabandi. The same finding was given in this case also by the learned tribunal that there was no purchase deed. If it is not purchased or not inherited by the original or owner, Lordship, his name had not been inserted in the Jamabandi or the Chita, Lordship. As it was already inserted in the Jamabandi, so how I am related with my father, to prove that fact only I have submitted that certified copy. And if it is a certified copy, Lordship, that cannot be taken.
Again, we are coming back to section 76 of the Evidence Act, Ms. Chaudhary.
Yes,
That shows that it's a certified copy.
Yes, Lordship. Section 37 says certified copy of a Jamabandi being a public document is admissible under the Indian Evidence Act.
Kindly tell us that document that you have exhibited before the tribunal was a certified copy.
That original was there, Lordship.
Merely having a document on the stamp paper will be a certified copy. Definitely not, because certified copy of a public document is again section 76. We cannot go beyond section 76.
Yes, Lordship.
Show us that it is.
Lordship, this is the procedure in the Bongaigaon district. They are.
Don't tell us that.
Lordship, for that, my learned friend was sitting nearby me on before some time, Lordship. He informed me that for this reason, Lordship, coordinate bench of this court already called the election officer, and thereafter nowadays Bongaigaon district certified copies are, Lordship, provided.
See, madam, that is not the thing. We are here and our decision has to be legally binding. We cannot bring something else. We have
Lordship,
to
for
be
that,
inside
if
this.
Lordship, that is a objection raised by the other side, for that this being not the certified copies, Lordship. For that, Lordship, at the time of trial, that objection has to be raised.
See, if certain documents are, you have already read that Mr. Mayang was reading. If certain document is not admissible, is it required to be questioned by other side?
No, the court has accepted, court has allowed
said?
us to exhibit.
It is
Court
not
has-
that acceptance.
It has already accepted those documents and
Yes, so
exhibited, Lord.
No, you are an experienced lawyer.
Yes, Lord.
After all, you have to assist the court to come to a definite finding. That's binding on law, right? No doubt. You've been engaged by your client, but simply that is, don't say that. You have to assist the court. That is what we are requiring.
That
Court is educating on the process on the law.
as those documents were accepted and allowed the OP to exhibit, so no objection was raised. So
Okay,
she
that is
cannot.
land document. What else about?
Land document and 1966, 1970 voter list, these are the vital documents of the OP to prove her linkage with her father. And she required to prove her linkage with her father only through, and Lordship, that
Now, can you
written-
tell us that land belongs to which particular part?
that is, Lordship, Kheluapara, Lordship, lot number 2, Kheluapara, Soptam, it is written there.
7, where you have stated that your father had landed property,
No, that was not written.
where your mother said that my husband had landed property.
No, that was not written in the written
No, no, in
statement,
the,
Lordship.
not, forget the written statement.
Yes.
In her evidence in affidavit.
No,
by
that
the
was not
DW2.
stated, but DW later on additional chief of opposite party, Lordship. In that additional chief, she has stated about the Kiraz Patta. that I, Hasina Khatun, wife of Nur Ali, daughter of Kapasu Sheikh, age about 43 years, by caste Muslim, by profession housewife, resident of village Kheluapara, Part 4, PS Jogigopa, District Bongaigaon, Assam, do hereby solemnly affirm and declare as follows, that in the lifetime of my father had possessed a plot of land measuring 1 bigha 4 katha. So after taking permission from court, she exhibited the document. In the village of Kheluapara, Part 4, under Boitamari Circle of Bongaigaon district. In this respect, the circle officer, Boitamari Circle, issued a Kheras Patta in the name of my father by Patta number 108, Dak number so. In the Patta, my father's name has been written as Kapasu Sheikh, son of Nobin Sheikh. Exhibit number 7, Kheras Patta, that my father expired about in the year 1993 at his residence of village Kheluapara, Part 2, under Bongaigaon district. That my mother's actual name is Fulbanu, and the same has been recorded in the voter list of 1966 and 1970, both by serial number 49 and house number 15. But in her
When did you
voter-
submit that particular document which you are reading?
This is Lordship, additional chief of opposite party.
When did you submit?
As per judgment, it says on the date 1960. Date was mentioned in the order itself. Page 17 from the bottom second paragraph. After fixing the date of order on 16/6/2016 before cross-examination. That is why I want to give reply to my learned friend's argument that after closure of evidence we have exhibited. That is not true. It was exhibited on 16/6/2016 and her statement was taken in the year 2015 or 17. Oh, that is 2015. I'm sorry, Lordship. Her statement was taken on 9/9/15. After her statement. The order itself says 16/6/2016. OP has submitted a copy of Jamabandi of village Kheluapara, Part 7, wherein it is stated that by order dated 3/6/2016 in case number so-and-so, passed by the circle officer Boitamari Revenue Circle, land covered by Dak number 798 has been mutated in favor of Hasina Khatun, Posiron Bibi, Begum Bibi in place of Kapasu Sheikh by way of inheritance. But neither the OP nor DW2 has stated anything about the land purchase document in the name of Kapasu Sheikh at village Kheluapara, Part 7. So rejection was only on the ground that we have not stated anything about our purchase deed. That is the ground of rejection. It was not stated that it is not a certified copy. It was taken later, it was submitted on after closure of the evidence. Those were not the grounds. And this is my challenge, Lordship, my writ petition. The state has not filed any writ petition challenging those findings, that those grounds were not taken by the tribunal, Lordship, in favor of them. So my humble submission, and this is my writ petition, Lordship, a new ground they cannot now impose upon the OP that these are the translated copy of the voter list. All the voter list are certified copies. These are public documents, and it is the procedure in the Bongaigaon district. They are, Lordship, providing these certified copies. There is no any, Lordship, effort by the proceedee to obtain fraudulent documents, or there is no allegation at all also that these are fraudulent documents, Lordship. And the tribunal has not stated anything that these voter lists are translated voter lists, so we cannot consider. That was not the ground, Lordship, assigned by the tribunal. And Lordship, regarding written statement, pleadings as per order 6 CPC, it says, Lordship, pleadings to state the material facts only. If, Lordship, these certified copies of voter list are not cannot be taken into consideration,
Do you have that evidence by which additional evidence was filed?
I have a copy.
No. You have read it from the impugn order, right?
Yes, Lordship. No, I have, Sir Rashid, I have considering this additional chief of opposite party, Lordship.
On which date?
Date is not mentioned here,
It is not available on record.
Lord.
It is
But-
because we have been telling everything with the order sheet
Lordship.
and the documents. Yes, there is a document of 16/6/2016.
Yes,
There is no such, which you are reading is not available before the tribunal. This is not a part of the record. On 16/6/2016, there is a petition for accepting of original land document.
yes, Lordship, that is after fixing the entire order
There is
itself
a-
says,
There is an application by the proceedee for accepting the original land document.
yes,
The document which you have been reading is not a part of the record.
Lordship, but this is in my
That's how that is
The
why I'm telling you,
court fee was also there.
maybe there, it is not a
Okay.
part of the record. You can come to the order sheet. 16/6.
Lordship. At the best,
Now on
Lordship,
27th of May 2016,
we can see from that, from the order sheet.
see, we are here, that is why I'm telling you. On 27th of May 2016, the proceedee present with her engaged counsel, fixed on 16/6/2016 for order. Later on, the OP has filed 4 numbers of documents. Now on 16/6/2016, OP is present, OP has submitted additional document, fixed 14/7/2016 for order.
Yes, Lordship, petition for accepting the original land
So
document.
that is what is the document. There is the document which you have been reading is not a
Yes.
part of the document.
Maybe that additional chip was not.
There is no
submitted.
additional chief. Where is the additional chief when there is no evidence in chief? There is no additional affidavit in evidence of the petitioner.
Lordship, in this case, your Lordship may kindly consider the case of the OP and your Lordship can remand it back. She may be
Whether
given
it
a
is
chance,
required or not.
she may be given a chance to obtain press certified copy, Lordship. If these are translated, if nowadays the press certified copies are.
MS R. Chaudhary, Lanet Council appearing for the petition. And Mr. S.K. Methi, Lanet CGC for the response number 1. Also heard Mr. J. Payang, Standing Counsel from Department for the response number 2 and 4. Mr. H.K. Hazarika, Learned Government Advocate Assam for the response number 3, or Mr. Talukdar, anyone. And Mr. Puli is here. Left, H. Puli, Standing Counsel, Elected Commission of India for the response. Here is the records of PNGN/FT case number 1476/07. That was called for the report by order dated 0405. Documents are hard.
Deeply applied.